हेलो। Page 1, serial number 23, page 2, 4 to 8, page 3, 9 to 14, page 4, 15 to 18.
Serial number 6.
15, madam. 1 week time. 1 week time. Serial number 15. Appeal for respondent. Serial number 15. Senior out of station.
How many times the adjournment is called?
Yes, in last 1 week in 15 years. Senior out of station. 1 week and expanding.
See, how many times the adjournment is called? Is it 2018 matter? It can't be adjourned. We'll see. Yes.
My lord, serial number 16. I appear for the petitioners in this matter. We're led by a senior counsel in this matter, my lord. There's a genuine inconvenience today. Only seeking 1 week's time.
My lords, in this matter, it was posted, senior counsel was heard on the last day. And before the trial court, they had agreed that the matter would be posted for judgment. So it was for me to produce the copy of the order date.
Yeah.
So I leave it to the court with regard to the
It's
request.
1 week's time, my lord.
It's not there.
My lords,
No.
Page number 5, serial number 19 to 25.
Lord, serial number 20, my lords. Appearing for the petitioner, my lords. Lord, senior counsel is not well, my lords. The senior counsel informed today morning, my lords. Maybe 1 week time may be given, my lords. They are not taken. Yes.
This adjournment of 2018 on whatever grounds will not be accepted. Whatever arrangements you have to make, please make.
Yes.
Yes.
My lord, my lord, serial number 19, my lord.
Yes.
We are filing amendment application today, my lord. So short adjournment.
We will see whether the matter is what is the amendment in the 2017 petition. We have to see. How can you find the amendment in the 2017 petition now?
My lord, my lords have advised us to file an amendment petition, my lord, in the previous hearing.
This is the matter yesterday it came up.
No, my lord. It was posted, I don't know the last.
Let's see whether the matter comes not. And I'm requesting advocates not to make any mention of correctly on these grounds of senior not well. No. Yes, next.
Page number 6, serial number 26 to 30.
Serial number 29, your lordship. Matter reserved for mediation today, your honor, 2:30. Let us, that is the reason. Let us fix the other date, your lordship.
Then after
Much, not 20, 1st August, 2nd August.
postpone.
What's wrong with this? Let's see. 5 weeks.
Much.
Page number 7, serial number 31.
Serial number 23. Serial number 23. I have filed objections in your counter
23.
arguments. Yesterday I have filed, they have not been put up. Our office may be directed to put up.
No other documents are filed here. No other objections are
Ah.
2023.
My lord, there were several documents produced before the trial court, but the same have been not produced by the petitioner. I have,
We call for that objection of yours. If it is not put up, we will call for it. We will-
arguments.
Yeah.
Please.
With regard to certain petition, I have a memo. This is the petition wherein the minor child was referred to be admitted to NIMHANS. My lord, here the child is required to be admitted to NIMHANS on 22nd, and from 22nd, the minor child she's having her exams. And my lord, there's one more modification that the mother seeks in this regard. So if the matter may be taken up at 2:30 tomorrow, my lord. Thursday, my lord. On Thursday at 2:30. Yes, ma'am.
About the date. And basing on that, the order is passed.
Yes,
So
ma'am.
why you realize right now? Suddenly.
My lord, the timetable was not provided to us.
Most of the
Kindly, madam.
Yes.
For being spoken to,
Appearing first. This matter, my lord, is small.
Petitioner, your lordship.
My lord, matrimonial matter. Your lordship directed my lord, the father to pick up the child from the school and to drop the child Sunday at 2. In fact, your
Lordship,
lordship.
we object, your lordship.
At his request, it is made as 2. Now, my lord, that topographical mistake, your lordship may kindly see. Order portions, that word and is typed a little later after 2 words. And I have carried out,
Your lordship.
One more thing.
but I have carried out in pencil, my lord, the correction. That will be easier.
Your lordship, if I may make a submission, your lordship, I'm for the petitioner.
Pick up the children, first one there. Pick up the children from the school on Saturday by 2 PM. It is typed now. Madam, school leaves at 12 o'clock. Leaves at 12 o'clock. He has to, he is picking up the children from the school. And next, it should be, no time need to be mentioned. Madam. I am not going, he is picking up from the school. Or 12 or 10 like that. Madam, next Sunday they have to drop back by 2 o'clock. But taking advantage of this, that is how it is.
Your lordship, we object to that, your lordship. That is not a typographical error. Your lordship, if you may remember, this is the matter where the mother had taken the children abroad to the UK when the custody proceedings were still going on. Your lordship, senior counsel has appeared in the matter before, and the arguing counsel is also unwell on account of dengue fever. We pray that the matter may be taken up on Thursday, please, your lordship.
But I too did not notice. But initially you were dropping back by 2 o'clock.
Lordship. Yes, lordship.
I thought,
Yes.
Allah, but that is apparent well, by Saturday and
It's not.
Simple thing. What is that you want to say? Now,
Your lordship,
according to them, The children from the school on Saturday, and he has to drop, there should be a time for that.
Very well, your lordship.
That's a clarification. But that's what arguments are required.
Your lordship, we have one point to make, your lordship, that we have a few points to make. If I may submit, your lordship.
He mentioned about only this. So, you know, that is submit only on that.
Your lordship, on practically every day, the children have been dropped off between 2 to 3 PM on Sunday by the father. Only on one occasion, your lordship, when there was, your lordship, genuinely speaking, your lordship, these are 5 and 7-year-old children, your lordship. To put them into such a strict regimen, such a strict routine, that immediately after lunch on 2 PM on Sunday. This is.
So some time has to be there. So that is, from the order it appears that it is not mentioned. It has to be mentioned so that there will be clarity.
Yes, your lordship. Your lordship, in that case, we pray that the time may be extended to at least 4 PM, your lordship, in that case. Arrangement.
Saying the time, it is about what is the vote. Even if it's 2 o'clock that day, if it is on Saturday, then it would be again, because the children
lordship.
have to study or not.
Very well. Your lordship, on most days, the mother on Sunday is not at home also. This has been recorded. She is a doctor, medical practitioner. The mother is not at home on most days. Now, what happens, your lordship, the routine of the children on Saturdays is that they have, on Sundays, is that they have lunch. Very well, very well. Yes, your lordship. Your lordship, our request then is that the clarification that they are seeking, the time may be put as 4 PM at least, your lordship. That is our only humble submission.
Changing what was said.
30 was originally.
Your lordship, if I may-
Originally, it was 12:30. Then court said 2 PM. We agree. Now there is by mistake that end is not, and has not come between Saturday and by. That is Saturday, it should come and by 2 PM. That's the only change. We are not seeking any change. Extension of time cannot be granted.
Your lordship, in fact, if I may take your lordship's attention to para number 5 in the order, or of the same order, your lordship. The last part of para number 5 reads as follows. This court deems it appropriate to give overnight custody of the children to the father so that it will help them to develop more bonding, which is required for the overall development of the children. Your lordship, by putting a strict regimen that 24 hours is when you will end your time with the father, overnight, yes, we are getting very well, your lordship. But true bonding, how will it happen, your lordship? I'm not going on merits. It's a genuine a sense of urgency. Your Lordship, we have actually been dropping the child off at 2 to 3 p.m. No, Your Lordship, what we are submitting is that such a strict regimen, because the timing is such that. Please.
Upon the site might tell you 100 things. Being an officer of the court, you know.
Please, Your Lordship, please.
Almost not yes, the present petition is filed. The matter is being appealed for it to fair. The order, the speakers are in order, and it is a feature from the school. And there was so in the court has mentioned that they have to drop the children out and the state is not signed the order. The order, that's where the master says they are doing it. We're also very good respondents of the staff. He's a petitioner.
I'm the petitioner.
Not hearing.
With the petitioner.
Yes.
There be problems that the order of the order page number in one it should be read like this. The father will exercise his discretionary sometimes. That is after the school hours, the father is permitted to pick up the children from the school and from the school. And on Sunday, he has to drop the children at the mother's place where he was from.
My lord, the school on Saturday. Yes.
The pick up the children from the school on
Saturday and
the children
by
mother's place on Sunday by 3 o'clock.
2 p.m.
3 o'clock, please, Your Lordship.
2 p.m. 2 p.m. Change month.
Serial number ported matter, serial number 2,
Change month. 3 number.
Gopal Krishnamurthy, C for petitioner,
Can I, my lord, it is mentioned as 2 over there.
3.
Where is it mentioned that the whole.
That 2 p.m. actually is mentioned. It is that and is typed.
And
Paragraph.
2 p.m.
Please,
Yes.
Your Lordship. Your Lordship.
Ported matter, serial number 2, Gopal Krishnamurthy.
This
C
case
for
appearing for
petitioner,
the respondent, my lord.
C Vinay Kumar,
Yes, ma'am.
Please. And it is a wife's petition for enhancement of the maintenance, my lord. Before the honorable trial court, my lord, she has filed the petition for the maintenance and wherein, my lord, she has filed the application for interim maintenance, my lord. That was allowed partly by granting her rupees 5,000 rupees. Lord, she has sought the maintenance of rupees 30,000 as a interim maintenance, my lord. But my lord, even though, my lord, the respondent is having a sufficient income and he is drawing a salary as 5,000 is granted, my lord. He is earning more than my lord, even as per record, my lord, he has not filed his assets and liabilities. My lord, when this honorable court was come down heavily on the respondent, then only he has come up with the, before this honorable court by filing assets and liabilities, saying that, my lord, he is earning 35,000. My lord, factually it is incorrect. He is earning more than 90,000. Lord, he is but he doesn't want to produce before the honorable court or before the honorable trial court regarding his salary slip, my lord. My lord, he is earning more than 90,000 rupees. Even we have filed application for 91 of CRPC to summon that document, my lord. That application is pending.
My lord, in this matter, both are highly qualified. My mother is staying at Sintamani. Yes. That's, yeah, and that's, yes, sir. One submissions in this matter, my lord. Both are highly qualified. My mother is a paralysis patient. Without cause of any reason, left the matrimonial house and residing at parents' house. Okay. Oh. Okay.
According, she has to file all the documents, you have to file all your documents.
Yes, my lord. One submission, my lord. Without reason left the matrimonial house, whether they entitled for maintenance, my lord. Please, my lord. Please, without reason left the matrimonial house and residing at parents' house, my Kaili, I am giving the reported some of the judgments, my lord.
But I have also three judgments of the Honorable Apex Court as well as this Honorable. Please, please.
My lord, in the latest judgment, my lord, Supreme Court. Please, my lord. In one judgment. Supreme Court latest judgment, my lord. I not had taken copy, only one copy has taken. Both are highly qualified, they are not entitled for maintenance, my lord. In this matter, both are the doctors. In our matter, respondent is a MBA, petitioner is a MCOM steward, MCOM. Without reason, left the matrimonial house residing here. My mother is a paralysis. I had to take care of my mother also. Thereafter, my lord, I arranged a separate accommodation also in Chintamani town. They are also not residing there. They come and stay at parents' house. I make an arrangement in Bangalore also, whether they are ready to come and reside, my lord. I will ready to arrangement in Bangalore. He is working in Bangalore. I has to take care of my mother as well as family also.
Which para of the judgment, please. The Supreme Court judgment you are relying on, which para of the judgment?
Paragraph of the judgment. It's asking which para of the judgment.
Oh, not it, not it.
So where the facts of the case are,
Please.
the judgment where the restitution of conjugal rights,
That's it.
an order is passed.
Sure.
Then there was a material before the court to say,
It's okay.
in spite of the reasonable cause, the wife is not staying
It's
with
okay.
the husband. I mean, that your case,
Yes.
that situation has not arisen now.
It's easy.
So this judgment is not applicable to the facts of the case.
Okay.
Then what about the other judgment?
Other judgment, my lord. Anil Jain and Srimati Sunita.
Count of what is
Yes,
done.
yes. See here in para number first. Yes, yes. Early Family Act 1984 has filed against the order of the 19 passed by the Principal Judge Family Court, Rathalam, criminal miscellaneous 203, 2014 year by directed the applicant husband to pay the maintenance 4,000 rupees per month to the non-applicant wife from the date of order. It has been admitted that the applicant marriage was performed and non-applicant 2001 they lived together for 7 days, second time 12 days. Thereafter, non-applicant wife has left the matrimonial house since she is living in parents' homes until she is enrolled as an advocate in that matter. Kindly see para number 9, my lord. The court has examined the finding the trial court whether non-applicant wife has a sufficient reason to live separately, whether she is unable to maintain herself. Admittedly, after the marriage, non-applicant living wife, matrimonial law 7 days, there was no allegation. During the period, she was harassed by her in-laws. Matrimonial law so. In this matter, they are not entitled for minute. Last parameter. The learned counsel for the non-applicant plan, the judgment reflects me by Patel Supra, the fact that this case is quite different. There are the not helpful for the non-applicant within the foresight. I am the view finding the trial court has non-applicants sufficient reason to live separately, not sustainable law. Non-applicant wife residing separately without any reason, she is not entitled for maintenance.
So, according to you, because she has left without reasonable cause, the husband is not entitled for maintenance. And you need not file the documents before the court, as she is not entitled. Is it your submission that all the documents as per the judgment?
Yes, yes, yes.
Rajneeshwar's names.
Did not be filed.
I know, I don't know. Can it be taken day after tomorrow or Friday? I will take it.
Kindly see,
Yes, yes, please.
Yes, it was not there.
kindly see the order sheet, my lord. The 3 times, thrice they were absent.
You won't come, when you come, you don't, no, what was the difficulty for you? No, when you.
And he is not paying the interim maintenance also.
File all the documents before, but you have not filed. So why can't we take an adverse inference? That you have not filed, and whatever she asks, we will grant. Because nowadays, it has become a routine practice that don't file the document before the court below, let it come to the high court, then before the high court, then you will say that we have not filed the documents, again the matter is remitted back to the court.
Yes.
So from now onwards, in all the cases wherever this statement of assets and liabilities are not filed,
Yes.
based on what the wife is asking, we will grant the maintenance.
My lord, kindly be posted this matter on 1 weekend. I will bring all the relevant documents.
Produce the
They say
entire order sheet of.
additional document has, this court has power, my lord, file the additional document in it. I can file an additional document. No, additional document I can file.
And it is before this or the trial court, you should have done it by that time. Why should that exercise be done by this court? Have you filed all your statement of?
Please, madam, kindly come to Annexure F. No, my lord, she's not earning anything.
As per that, file your bank statement,
Which
bank statements.
is it back?
Even your bank statement.
No, madam. She does not have even account, my lord.
Yes.
No, my lord, because my lord, page number 40, Annexure F. I filed the assets and liabilities. BCom, my lord. BCom.
MCOM, madam.
No, MCom, it is not
MCom.
completed. No, madam, she was not. No. She is, please, madam, kindly come to page number
That
40.
affidavit,
madam.
so they said that
Bracket, we
MCOM.
have specifically mentioned, MCom is not completed. By that time, she got married, madam.
Why she can't work?
Because, my lord, earlier also, my lord, she was not,
She has to be.
little paralysis patient she is, madam. That he also knows it, and he himself has admitted to the hospital. That also he admitted that, my lord, that he knows it very well. And before the honorable trial court also, my lord, the 80,000 due is there. 1,10,000 was the due. 30,000 he has only paid. 80,000 as on today it is due. My lord.
Please file for the wife.
No, my lord, by him only restitution of conjugal rights he has filed, my lord. He has withdrawn that. Now again he has filed the divorce petition. Now it is pending for consideration, my lord. And I have produced in 3 citations, my lord. Honorable Apex Court Anju Garg as well as the coordinate bench of this honorable court, 2 citations.
I will ready to make an arrangement, alternate arrangement in Bangalore also. Because of I have to take care of my welfare of my mother also, paralysis.
Even basically. The last update is the file. The next we reverted the husband. And we don't look after the only parents to the husband. That is not exactly. Also, due to the wife that is. So it's the husband. Thank you. Yeah, we created that's not traditional about the statement of assets and liabilities. Both the parties.
But the impugned order is at Malada 5/6/2020. Sorry, the order is dated Malada, the impugned order. 25/3/2023, Malad. That your lordship will get at page number 57. Please.
That is that the narrative has stated. Had not filed this, the salaries. We also other particular. By granting maintenance, the board will also have considered all the. In order, insisted the party file their respective statement. And. This order that we passed the report. Contrary to the. Solid on the ground level. Even if according to the court will consider the income at 30,000. The court of even for that was granted an amount that the council of the respondent husband can't document that as the totally in the husband. So consider the providence of the judge. All those judgments do not apply to the fact of the case as those judgments already a judgment, already a judgment in the field. Right, rights, and the scene was not complied with, the courts of takers of the incident can be divided. That's not the case. Considering the fact that the court has not displayed anything of possessions and liabilities. Also, the husband has not the concerned opinion of this. According to order, is set aside. The matter is demanded after the fact. In one mark, the pages of this form. And it was still the application to the law. The petitioner is entitled to make the. If the husband is not coming up and finding all the documents. Then after simply.
Great.
detail number 3.
I appear for petitioners in this matter, my lords. I'm challenging the maintenance order in this case, my lord, wherein the trial court has directed me to pay 8,000 rupees every month, along with 10,000 rupees of litigation expenses. My lords, I'll just give the brief facts of this case, my lords. I got married to respondent on 12/5/2022. 12/5/2022. On 7/8/2022, the respondent leaves the marital house after removing her Mangal Sutra along with all her belongings. Even during this tenure, my lord, she has lived along with me only for 27 days. And then I filed a judicial separation because she's prone to attempting suicides, and she also attempted suicide. In that fear, I filed a judicial separation petition. Subsequent to that, they filed a restitution of conjugal petition. I withdrew my judicial separation petition because in between, they also filed one false complaint against me and my family members. I filed a counterclaim asking for the divorce. They filed an application seeking for the interim maintenance, my lords. While filing the interim maintenance application, they've suppressed her true salary. Her salary, they state that it is 58,000 rupees. In our objections, we stated that she's provided all old salary slips. And apart from that, she's been investing like in the assets and liabilities affidavit. My income is 2,27,000. But
2,97,000.
2,27,000.
Now you have produced fresh valuation. You only
My
produce.
lords, they've also produced their salary slip, my lords. In the assets and liabilities affidavit, they state that their salary is 58,000 rupees. I'm sorry, ma'am.
What is granted 8,000?
8,000.
Technically, your salary is that 20.
True, ma'am.
5,000 or 97.
True, ma'am.
Let's take lakhs into salary.
Yes.
So what has been granted by the court is 8,000. So how are you agreed?
My lords, my only contention. She is earning 78,000 rupees, my lord. She suppressed 20,000 rupees.
This is earning 38,000. You are earning 2 lakhs. So what are the difficulties paying 8,000?
My lords, I've also got other liabilities, my lords. My only contention here is, my lords.
8,000.
True, my lords, but she also has other incomes. In her assets and liabilities affidavit, along with the documents, whatever she's produced, we've identified that she's also investing in equity shares. She's inherited a property after her father's demise. And she's also sold some properties and she's got this thing. My humble full submission here is, my lords, why should she be entitled for the maintenance after she's intentionally falsely deposing to the affidavits? I'm relying on this judgment passed by the Delhi High Court, my lords. Here,
How does this court decide that? Like, falsely.
my lords, there was a direction given to both the parties to produce their salary slips. It's quite evident that she suppressed the salary 20,000 rupees less intentionally. This was also brought on in our objections. But the court has not
No,
considered.
no, my lord, that is not true because I'm getting a 57,000 income.
The opinion of this court, that's not a big amount. But what if at all any suppression and other facts were there? As for the judgment of the apex court, it's for the lower court to decide. Let the court decide that. If there is any suppression or misrepresentation in this court, the court has to initiate appropriate proceedings. That the lower court will take care. The trial court will take care.
Sure, my lords. Accordingly, it may be done.
My lord, my lord,
Sure.
my lord, one submission. My lord, I filed a affidavit under salary slip, that is a 57,000, the net salary. What I'm doing the extra work, that is, they're adding, my lord. That is not, yes. And I filed this one, my lord, I filed it for enhancement, Another.
3.1.
Kindly they produce this honorable court guy directed to produce the recent salary slip. I have produced, kindly look into that, my lord. Now, as on today, my
Expenditures.
regarding. So I'm incurring, my lord, my mother has performed the marriage by spending a 40 lakh. So, my lord, within 2 months, the conduct of the respondent, we have to look into that, my lord. I requested, I filed an application for restitution of conjugal rights. Even till today, I'm ready to go join with that. And they have snatched my Mangal Soda they're keeping. They don't want to give now. Yes.
Said, wanted how much wages? How much is got?
1,25,000.
1,25,000 I sought.
And 3 lakh rupees medical expense.
No, what is the breakup? What are the expenditures, please?
Yes, yes, my lord. In application, kindly.
The expense.
In present writ petition, page number 120, my lord. Yeah, in application I mentioned. 120. In supporting of application, I filed affidavit. 120, 120. 120. I submit that now I am presently working so and so. Monthly expenditure of mine rupees 25,000. Monthly expenditure of dependents 25,000. Monthly EMI, my mother and unmarried sister. No, no, my lord, because I performed the marriage by spending a 40 lakh, I'm paying a EMI to that marriage expenses. So that I'm is well off, is earning a 2,97,000. And is well off, is residing in triplex houses, and they're getting a income, rental income more than 75 to 1 lakh. Their
That's false,
parent.
my lords. There's nothing in my name. They've not produced any documents.
That is your, so,
Yes.
so therefore,
You have taken loan,
yes, my lord.
but marriage you have taken loan.
Yes, my lord.
No document produced, my lords.
This is, I submit that the respondent now earning so and so. He's, my lord, not only 2,97,000, he's doing a,
This expenditure at 91,000, what happened to the remaining 35,000?
My lords, if I may point
Yes,
out,
my sir,
serial
yes.
number 3.1, in paragraph number 21. Here they say that our liabilities are only 67,000. My lord, serial 3.1, page number 8, paragraph 21.
Page number 8.
Page number 8, my lords. Serial number 3.1. My lords, I think that is serial number 3. I request my lords to refer 10177, serial number. That is along with the documents filed by both the parties, my lords. Assets and liabilities affidavit and the documents. No, no, I'm referring to their petition. Petition filed by them, serial number 3.1. 10177 of 2024. Page number 8, paragraph number 21. Now here they say that her liabilities are 97,000 rupees in odd. In the petition, they say that her liabilities are 67,000 rupees, wherein she's taking home 78,000 rupees.
Page number?
8, my lords. Paragraph number 21. Admittedly, the petition is also working and earning 58,272. Even in this petition, they misrepresent. This petition was filed on 19/3/2024. In this petition, they state that the petition is also working and earning 58,272. Again, they are misrepresenting here. But her liabilities of 67,000 per month. But in the assets and liabilities afterward, they state another figure. Wherein, as on today, she has been drawing 78,000 rupees home. My whole contention is this, my lords. She is misrepresenting all the facts and she's still entitled for the maintenance. Hence, I am relying on the Delhi judgment, my lords. Yes. Sure, sure. If my objections is taken into consideration, my lords, I've also pointed out stating that she's not given bank statements. She's only given, again, she's given only old bank statements. From whatever bank statement she's provided to me, I've also identified.
As per the judgment, when is this petition filed?
This petition was filed on
22.
2022.
Yes,
2022.
2 years.
Bank statements which year need to be filed?
From February 2023 to the date of application.
Saying that the vendor of that is by deciding this application. The application is filed in 2020.
Yes, ma'am.
The bank statement should be of which year?
The present year, 2023. 2022, and at the time of filing the application also, so 2023. So she is smartly not provided the bank statements belonging to February 2023 to August 2023. That is on the date of filing the application. Because her salary was increased. She's filed only February 2023 salary slips and bank statements.
Bank statement?
Of April 2021 to 2023. So she's intentionally not filed from February 2023 to August 2023. That is where the salary hike happens every financial year. So till now, she's had 2 salary hikes, which she suppressed before this court. So that is why I'm submitting, my lords. They've suppressed 20,000 rupees less. They've stated 20,000 rupees less in their assets and liabilities affidavit.
According to your 2 lakh and order,
Yes, my lord.
what are your expenses?
My lords, I have 2 loans, my lords. One is my father has a property wherein I've borrowed a loan and I'm constructing the property. One. And second thing is I've also borrowed another solar panel loan. For all of it, I produce the documents. Apart from that, I am the only son who's taking care of my father and mother.
My lord, I produced the salary slip before this court. Yeah, and filed on 4/7/2024, separate memo.
In serial number 3.1.
No, separate. I'll submit, please.
Yes.
My lord, now grass earning, my lord, 78,000 now, after lapse of 2 years. When I filed in the 2022, writ petition 24. Yes, my lord.
What is that? When you're filing, when you're selling to this affidavit, you're not supposed to say that your salary is what today.
So that has been increased. I filed, my lord, when I filed an application at that time. Yes.
Who says when the complete salary? Karnataka 21.
Yes, my lord. 58,270.
What did you say this? When you're earning 78,000 and all.
Oh, my lord, because of I stated in when I filed application in the year 2024, that application that of contention I stated before this court. My lord, the respondent also not whispered regarding, as on today is drawing at 2,97,299 rupees. He is not also whispered in the writ petition, present writ petition. Kindly look into that.
My salary slips can be compared along with the
Yes.
affidavit, my lords. It is actually less now. My lords, I've stated the true facts itself here. In fact, my salary is 7,000 rupees less compared to my the recent salary slip and this. I've stated the same salary itself here.
He has not whispered in his written state, in his writ petition,
My lords.
regarding how much he has earned.
Because my salary is not deferred, it is actually reduced. But I'm not taking that contention.
My lord. No, my lord, I filed a bank statement in the court below. And I produced the salary set. My lord, yearly wise, 5,000, 10,000, my lord. In the year 2022. In the 2022. Yes,
Application was filed on 23/9/2023. 23/9/2023. 3/9/2023.
23/9.
Yes.
Why she has not done it bank statements? What is the, please, do you have the bank statements prior to 29, from March to this 23/9/2023, the bank statement?
23/9/2023. I've produced, kindly look into that. They are.
According to.
It is not. They filed their application and assets and liabilities along with the application itself, but from February till this date, they've not produced the salary slips and bank statements.
Yes,
They've also not produced the IT returns.
Kindly, they produced, my lord, additional, along with salary certificate, the respondents, the petitioner, in page number 33 onwards. So
My
their
lords,
case, my
my
lord,
salary slip.
1458 of 24. Thirty-three onwards, my lord. The bank statement, Nandana. Additional they filed, my lord.
These are the same documents filed by them in the trial court, my lords, which I filed along with the memo dated 5/7/2024
Page number 33.
in serial number 3.
Kindly runs from 33 page to 121, my lord. That Kotak Mahindra Bank.
My lords, kindly.
No, it runs the 100 pages. 21 to 23, my lord.
Then, as on the date when you file the application, that you're not supposed to file. You filed it in the month of, which month, September?
Yes, my lord.
But then why you have not filed September? So August, September, 23 August, September, please show.
23 August.
It's not there.
No, my lord, it's up to February 23. That's it. No, my lord, that is regarding only because I produced the salary certificate along with the application. That is a 57,000. Now I produced the salary certificate. Kindly look into that salary certificate of respondent, my petitioner, my husband.
My lords, one humble submission, my lords. I'm just relying on this judgment.
My lord, in this case, that EMI of solar already cleared. And 1 crores 94 lakh, they have taken a loan. It is not to the grant salary. I sought, my lord, 1,25,000.
$18, my lords. Wife, respondent wife. Counterclaim seeking for the divorce.
making it long. If you try to fall under we can start the monitoring at the microphone. And also, if you're not even a previous program system. So that you can hospital and you have a delegate. At the also, looking at the document file for the report. One of the that is five things that you really graduate, working as staff consultant with the app and technology services. Money gets salary of these three problems. They borrowed the amount of the 6,25,000. 6,60,000 from Central Cooperative Society. And according to the respondent, he has to maintain his parents. His salary is 2,27,000. They have borrowed construction loan from SBI and solar panel loan from the other. Then he paid EMI of 1,70,000 towards housing loan. The 45,041 to the solar panel. So, who also observed that the wife has offered medical expenses 3 lakhs and it's the burden on her what is it do that to that here to spend that amount. And the poor Sardar, the which is not proper to direct the respondent to pay the unexpected. In the body, that response and the function is good. And the body do that. That the party who has come to the court with sufficient use certificate to pass is not entitled for any relief from the court. He submits that when the petition is filed in the month of September 2023, conveniently, he had not filed the application has gone till February as the user salary had in the month of March. Further, he submits that and he states that for the performing the marriage and loan and prepayment, none of those documents are used for the court. It is submitted that how much salary is 70,000, 78,000. In such fact, is not stated either in the year the petition that is filed in 2024. He submits that. Yes, but in the statement of assistant liability, it liability is 1,25,000. Whereas in this petition, in the grounds that are raised, it is stated that it is 75,000.
Para 23, my lords. Para 23. Just a second. For para 21, it is stated 67,000.
Stated that. It is
67.
and 20.
1.
The statement also responsibility and in that it is running an amount of 58,000 and by the date the salary is already high. It was 78,000. He submitted that this year also in the expenditure has shown for 25,000 spent in the parents. But it's that the petition after we do not have to maintain her parents And the salary she is earning, if she is able to maintain herself, the application and it is further submitted that the market can take at least from 25 to. If it is an option. that's very good. And get the home. Some start is not exactly what I need. Can rely on the judgment of the living like that. Would be from. There is a lot of.
Paragraph number 13, my lords. We find in the present case, it is not only that the appellant is highly qualified and has an earning capacity, but in fact, she has been earning, though has not been inclined to truthfully disclose her true income.
The appellant there is highly qualified, has earning capacity, but in fact, she has been earning, though has not been inclined to disclose her true income. Such a person cannot be held entitled to me. But it is the case for maintenance child care. The government has also let the same say. The accounting attorney to the respondent. The husband has also suppressed his income, only earning 1,97,000.
2,09,000.
2,97,000. Is that accurate?
And number two, my lord, solar loan has been cleared within 6 months, but he has mentioned 45,000 every month. 1,70,000 he has taken. 45,000 per month.
The husband has come to this point, the separation of and the fact that he has to pay the game money and other loans, the wife is entitled for the entitled for the amount as claimed by the court without any delay. And the amount of and the same needs to be.
That's
Parties were paying the lease. Yeah. Insufficient on view of them. In the time between possibility. Conflict explores in the has led to this aspect also. When the parties of the file get stated about it. And any of the statements that are made before the court. Court, if there is any a false submission that is made before the court, then the court will initiate appropriate against the party. From the pleading that are based with the time of dissent, it appears that from both the parties, there are sufficient of which the court will have to conduct a hearing regarding this.
One submission. I've not suppressed any facts, my lords.
That about your, when was your loan period?
At the time of filing my application, the loan was active.
No.
I've not suppressed any facts, my lords, including my salary.
As of now, because that loan is 45,000 or 1,50,000.
Both of them, I produced the bank statements, my lords. I've even produced the loan statements. Yes, my lord.
Did you say that the loan is clear?
The solar panel, except that I've stated all those things, my lords. Just the solar panel thing I've not stated. But to be honest, even I'm not clear with those facts, my lords. I'll have to check with my client.
No, but that's why if it is, that is what is.
If there is, yes.
So, if you there is sufficient of fact for the party. Not of the matter. The order under, the executive order is set, right? And the court below can consider all these, all these conditions based on behalf of both the parties. And basing on, and the rights are also by all statements, right from the day the petition is filed till now.
And her IT returns. Her IT returns as
The
well.
IT is also asked for the statement. Based on that, the court will pass appropriate order. And if the submission is there on behalf of either of the party, then the court will initiate the appropriate action. And the material that is filed, the affidavit, the ground, and the petition that is filed before this court, also the registrar is directed to send the seed records also to the court, so that the court will be able to appreciate the matter in a better way.
Application direction to dispose of the application. Much.
Till number 4, Kiran VS petitioner.
Kindly pass over the matter, ma'am. My seniors are appearing before this court to make a submission. That was some personal interest.
Till number 5,
I am for the petitioner.
My lords, in this matter, I appear for the respondent society, my lords.
My impugned is page 102, my lords. 102. Yeah, just read the interim order. The impugned order. I am for the plaintiff, and the suit is for injunction and recovery of damages to the extent of 30 lakhs. Property belongs to the plaintiff, that is the petitioner. He purchased in 99. In 2000, he constructed the compound wall. In 2013, new structures were erected, 9 sheds were erected there. And this property was leased to 9 employees who are working nearby. And one premises was given to the another tenant. So the premises, entire premises consisted of 9 sheds and one big shed, industrial shed. Our photographs have been produced. In the month of April 2016, my lords, this defendant, no, defendant is not detained. Defendant is society. Interfered and demolished the structures on one particular date. That is on, yes, my lord, the date is 20.
Where is this property situated within the jurisdiction of the contractor?
No, now it is in the municipal limits. Earlier it was in the panchayat limits. Since
BBMP.
yes, BBMP, my lords. BBMP and Kata has been transferred. Assessment has been done. I have produced all the documents. May just kindly look into it. Present IA was return statement they filed. They filed an application. They filed an application to dismiss the suit under Order 11 Rule, Order 7 Rule 11D. Rejection of the plaint. What the trial court has said, did not reject the plaint. Trial court said you have to represent the plaint after issuance of the notice and 125. It presupposes, yes, my lord, it presupposes that the dispute relating to the society or management, that is not the case, my lords. So therefore, I have come before the sample court.
And the other day you said about some problem.
Exactly. Say 125, my lords, that is the. Now, according to this, yes, my lords, page number 102, my lords. 102. 102. The above suit is filed against the first defendant, Aircraft Society, and another for relief of permanent injunction against injunction and damages, 30 lakhs. The plaintiff has not alleged in the plaint what is the business of the first defendant corporates as on the date of filing of the suit. I didn't know what about the all these things. Then, my lords, however, the first defendant, its written statement in para 2 has pleaded that the defendant number 1 is a cooperative society registered in the province of the Cooperative Societies Act. The defendant number 1 society is constituted for the purpose of formation of layout and sites to the members of the society. There are about 13,000 members in the society. The members of the defendant number 1 society are all employees of the HAL. No person who is not an employee of HAL is a member of the defendant society. In Bangalore, the complex of HAL, there are about 14,000 employees. Most of the members either belongs to the middle class or lower middle class. They do not possess any building or the site. There has been acute shortage of accommodation in Bangalore. This society has been taking steps, making provision for allotment of sites. And hence, it appears to the court that the business of the first defendant society is the formation of layout and sites to the members of the defendant society. Then, however, the plaintiff has not issued notice under 125 of the said act. Section 125 notice necessary in suits. No suit shall be instituted against the cooperative society or any of its officers in respect of any act touching the constitution, management of the business of the society until the expiration of 2 months. Next, after the notice in writing has been delivered, the registrar or left in his office stating that the cause of action, name of this, all these things. Then order 6, rule 6, CPC, the condition precedent, any condition precedent, the performance of the occurrence of which is intended to be contested shall be distinctly specified in his pleadings by the plaintiff or defendant as the case may be, subject thereto an averment to the performance or occurrence of all the last, my lords. Yes, yes. Now, my lords, in the objection written statement, sorry, in the application under order 7 rule D, I have filed objections also. I have said, while passing the interim order before this, before the trial court, the trial court has rejected the office objection and said no notice is required, and therefore court has granted interim order. One, exactly, by memo, my lords. I have produced it by memo. I have produced the. Yes. Yes, ma'am. Page number, my lords. Memo dated 4/7/2024. Yes, my lords. In the page number 3, my lords. Heard the advocates. Got it, my lords? Yes. They heard the advocate for plaintiff, produced the official objections. The plaintiff has filed a suit for permanent injunction and damages against the defendants. The defendant number 1 is the Housing Cooperative Society. The plaintiff has sought for the said reliefs based on his title. Dispute between parties is not touching either constitution or the management of the society, so as to attract the province of as contemplated 125 of the Cooperative Societies Act. The plaintiff has produced the original documents under list. The same shall be kept in safe custody. The plaintiff has sought for similar relief of temporary injunction under order IA 1 and 2. After having heard the counsel for the plaintiff, I have perused the affidavit of the plaintiff accompanying so on. Yes. No. Yes. Yes. Now the second time, unfortunately, sorry, learned judge. Yes, ma'am. Yes, exactly. All right. In the page 1 or 2, my lords, I'll just read the section 125 of the Act. Yes, ma'am. No suit shall be instituted against a cooperative society or any other office or any of its officers in respect of any act touching the constitution, management, or the business of the society until expiration of 2 months. Next, after notice in writing has been delivered to the registrar or left at his office, stating that the cause of action, the name, description, place, and so on, so plaintiff and relief which he claims, and the plaintiff shall contain a statement that such notice has been so delivered. Your Honor, my lords, your lordship is aware, under CPs also there is a provision at section 80, you can't file a suit. But there is a sub-rule 82, which authorizes the court in a special circumstances, court can grant relief. Similarly, my lords, against a corporation, if you want to file a suit against a corporation, you have to issue a notice. There is a special provision and so on. Here, there is no such provision. The problem is, assuming for the moment, my lord, just only if notice is required to be issued, In every case, my lords, if there is an interference, when it doesn't touch the constitution of the management or the business, they come and demolish the building. I have to issue notice, wait for 2 months. By the time debris will also not be there. In fact, in this case, injunction order has been granted. They have removed the debris and everything by violating the court order. I have filed an application order 39 rule 2A for contempt action. That application is pending. That apart, my lord, we filed an application calling upon them to produce. They said that this property is acquired and other things they said. If you have any such things, please produce before the court. There is a direction by the court to produce all the documents relating to the acquisition. They did not file. And they choose to argue the matter on this point. So the trial court has passed an order. Of course, the judgments which have been cited, written arguments have also been filed before. It has not rejected the plaint. One thing that the court has done is, it has not rejected. Their application is virtually rejected. And the court said, you you withdraw it.
One notice to be given, the expedition is pending on 17th.
Two things, my lord. Yes, my lord. Your lordship is right. What prevented you from issuing notice? Why should I issue notice? This presupposes, my lords, I don't know who you are. You have demolished my building. You are liable for payment of damage. I can understand, my lords, if then. Yes, my lords, that's. My lords, when my, exactly. You're 100%, my lords. The second is, my lords, the trial court, as if the trial court has considered this aspect while granting interim order. If I've cited the judgments, 5 to 6 cases I've said. I've filed written arguments also, my lords. Written arguments on 4-7. There is a similar case, my lords. The 126 of Andhra Pradesh Cooperative Societies Act. That is analogous to section 225. In fact, Andhra Pradesh High Court, page number 54, my lords. There also said, page number 54, my compilation. This last judgment, I will only take your lordship to page number 54. Objection was raised, the second para last was raised for the maintainment of suit on the ground that notice under section 126 AP Society was not issued by any appellate court, by the appellate court before suit was filed. Therefore, its judgment dated so-and-so, trial court dismissed the suit on finding that this is defective or for non-issuance of notice. Finally, my lord, court said no notice is required. Since this court has taken a view, last page 56, that the notice 126 of the act is not mandatory for the suit filed by the appellant hearing, the matter has to be decided afresh on merits, duly giving opportunity to the parties. This is so far as 125, 126, same provision, my lords. Now I'll just cite the first judgment, my lords. That is in page 12, my lords. That is Deepa Housing Cooperative Justice Arvind Kumar's judgment. This is, I'll only read page 125, page 13, para 9, my lords. A bare perusal of the said section would indicate that no suit can be instituted against a cooperative society or any of its officers in respect of any act touching the constitution, management, or business of society until the expiration of 2 months next after issuance of the notice in writing has been issued society. Interpretation of 125 of the act came in for consideration before the full bench of this court in so and so, so and so. Then, my lords, in the para 13, my lords, I'll only read that. The plaintiff is seeking relief of partition and separate possession in respect of social property. Incidentally, in the pleading, it has been contended the plaintiff's husband, the first defendant, and father of defendant 2 to 5, Chelwe Gowda, during his lifetime, had fraudulently and misrepresenting himself as only son of so and so, had got the Kata of social property changed to his name, contrary to so and so. And there is no plea against defendant 6 and 7 except the extent showing the so and so. I'll not read that. It is the last paragraph, page 14 minutes. Though SP Kulkarni and Rand Council for appearing for revision petitions, the defendants vehemently contended, said order was passed based on the concession or conceding the plea before the court by the learned counsel for so on. I am not impressed by the said argument in inasmuch as coordinate bench of this court, having examined the plea paragraph 4, has held such notice was not required to be issued before the institution of the suit. It also incidentally noticed that the land counsel for the plaintiff has accepted the said proposition, and as such the order came to be passed by the coordinate bench of this court, and as such it cannot be construed as an order passed after learned counsel had considered. Hence, the court is of the considered view that there is no irregularity or illegality committed by the trial court in rejecting the plea based on maintainability of the suit, calling for exercise of the jurisdiction. For reasons, I proceed. The revision petition is hereby dismissed. Order passed by the civil judge JMFC is hereby affirmed in view of the revision petition being dismissed. Then, my lords, the second aspect, my lords, that is the second case is Hanumaka. Yes, my lords.
Yes. Yes.
My lords, am I audible, my lords?
Yes, you're audible, please.
Please, my lords. Apologies, I'm appearing through VC, my lords. Some personal inconvenience, my lords.
Yes.
My lords, this is a case, as my learned friend stated, this is a case where section 125 of Karnataka Cooperative Societies Act was not complied with. Apart from that, Order 6, Rule 6 clearly contemplates there's a condition precedent where they ought to have complied with of serving a notice of 2 months prior before instituting the suit. My lords, my learned friend here is telling we can give a go-by to this. Only when this does not touch the constitution or management of the society, my lords. My lords, however, in this case, my lords, the respondent society, as the name itself tells, we are predominantly engaging in forming layouts, distributing sites to the members of the society, my lords. Aircraft employees, house building cooperative society, my lords. My lords, this matter has gone up till Supreme Court, and the same survey number which is a subject matter of this case, my lords, has gone up till Supreme Court and has come, my lords. The peculiar facts of this case are, my lords, preliminary notification in the year 1988 was issued by the government, my lords. My lords, these are part of trial court records, my lords. If I may permitted,
Those are not the issues. Now we are only on the question of 125. For that, we don't have to look into the other aspects. Only you have to tell the court why a notice is required under 125, whether this falls under 125 or not.
I understand, my lords. To establish that only I'm trying to tell, my lords. My lords, the main, if I may read section 125, my lords, of Karnataka Cooperative Society.
I have read, you can submit.
Please, my lords. My lords, the main constitution and management and business of the society is forming layout, my lords. In order to do that, land acquisition was done of this survey number 105/3 by the government. Preliminary notification was done in 88. Final notification was issued. The plaintiffs, that is the petitioners, vendors, have received compensation. My lords, kindly see their sale deed, my lords, in the year 1998, which is part of
simple. Submit before the court all those things, their case will be dismissed.
Please, my lords, they let them represent before the
Any judgments you are relying on?
My lords, I need some time to produce.
No. This is the second time you are seeking time. It can't be.
My lords, kindly see, my lords. My lords, if I may submit, my lords, I will produce 2 judgments of pertaining to this case, my lords.
Not this case, on law.
On law, my lords, on
what
law.
is the judgment?
My lords, may I request my learned, my colleague is present in court, my lords. WP 5798 of 2006.
Pass on. Yes.
My lords, this is a matter where plaintiffs, that is the petitioner's vendor, has approached this honorable court, sought to challenge the acquisition proceedings, my lords, pertaining to the same survey number 105/3, my lords. My lords, this honorable court has dismissed the writ petition and upheld the land acquisition proceedings. May I read the relevant portion, my lords? In page number 20 and 21, my lords.
That is not relevant. That you're not understanding. Those are not relevant for this. we'll assume that this writ petition is dismissed. I'll record that.
Well,
The vendor's writ petition questioning the acquisition was dismissed and the acquisition is upheld. We'll take it further. We don't have to read this order.
Kindly see, I understand this is not relevant to this proceedings. I'm bringing to my lord's notice because this writ petition, the current writ petition arises out of the same property,
That's
The
what,
land acquired and given it to me. The vesting has taken place in my.
I'll record that. I'll record that. We don't have to read it. I'm taking whatever you are saying on the face value of it. And I'll record that the proceedings have attained finality as far as the land acquisition is concerned.
My lords,
Yes.
I won't bother you then, my lords. I'll submit 2 other judgments of this honorable
Yes.
court.
Please pass on all the judgments, whatever you have.
Please, my lords.
Yes.
My lords, apart from this, also one technical objection I would like to raise, my lords. This is an order passed on order 7 rule 10, my lords. This present writ petition is not maintainable as the CPC already provides for a provision that is MFA, my lords. My learned friend has filed a.
If your application for rejection is allowed, then an MFA. Yes, not when it is not allowed now. It is like it is it has passed it has passed a via media order. Yes.
Please, my
What
lords.
is the judgment of Justice Abdul Nazir?
If I may read RFA 1966, my lords, passed by this honorable court, Justice Srishananda, my lords.
Yes.
The relevant portion, my lords, similar set of facts, my lords. There is there is no difference at all, my lords. Kindly see para 11 and 13. That is the operative portion, my lords. Admittedly, the defendant society is engaged in the business of forming residential layout and distributing the sites to its members. Accordingly, plaintiffs are the absolute owners in survey number 7/1, and on the western side of the plaintiff's suit, admittedly, there lies 17 guntas of the defendant. According to the plaintiffs, defendant has played fraud on the plaintiffs and manipulated certain documents, resulting in the suit has been filed against the defendant. Section 125 is culled out, my lords. Kindly see para 13, my lords. A coordinate bench of this honorable court in so and so as held in Supra as held in para 11 as referred to Supra. On conjoint reading of both the provisions, a suit against a cooperative society is no doubt maintainable if suit does not want to if suit does not want to try the rights of a cooperative society in respect of matters not touching its management or business. Otherwise, prior notice of 2 months period is very much necessary to be issued to the registrar of cooperative society, and on expiry of 2 months, suit can be entertained. My lords, kindly juxtapose this with our case, my lords. My lords, the suit filed by my learned friend, my lords, it touches the management and business of the society, my lords. A notice of 2 months prior ought to have been given, my lords.
Yes.
Reading further, my lords, in the plaint, the business of defendant society was sustained, and the same was led to be adjudicated. Under such circumstances, trial court forming an opinion that prior notice having not been complied, the suit is not maintainable, is based on factual and legal aspects. Accordingly, the court is of the considered opinion that grounds urged in the appeal are not sufficient enough to admit the appeal for further consideration. Therefore, the appeal is declined, my lords. My lords, on the same lines, my lords, Justice Nazir's order, my lords.
I have seen that.
Please, my lords.
Yes. I have seen all the judgments you have passed on. Yes.
My lords, if I'm not able to convince my lords, can I request for a short date? Day after, my lords, I will come in. Today,
I've already spent enough time. Please understand that can't be possible.
one submission.
Yes.
Abdul Nazir's,
I've seen that.
In fact, court
reply is
said,
required.
125 is not required. That is what para
I've
12
seen
says.
para number 11.
Exactly.
Yes.
Para 11 and 12.
Yes. Agreed with the order passed in Page number of the impugned order.
103, my lord.
Agreed with the order passed in IA number. What is this IA? There is no IA.
I'll. Index LA, this is, yes.
Unfortunately,
IA
the
number
court
three,
order
my
do
lords.
not
IA
disclose
three.
anything. Court has to search from
No, I'm
everything.
sorry, IA 3, my lord.
Not about you. The court is not mentioning anything, the
Yeah,
trial
yes.
court, sir.
It is available in page 80, application is available at page 84.
No, let's see the prayer. Where is your prayer?
Prayer,
Page
my
number?
lords.
IA number 8, my lords.
IA number 3. For the initiating the accompanying, it depends
Uh,
on, some are pleased to reject the plaints. And they have taken the ground also.
It
This
is IA
application-
number, I think, 7, no,
No,
not
3
12,
minutes.
IA number 12.
3 minutes.
Where is a
It is there.
plaintiff OS number? You don't mention even in your prayer also what is IA.
Page number 84 of the writ
No,
petition.
in your prayer before this court, you don't mention that, which prayer, which IA has to be set
Yes,
aside.
yes. I'll just come to that. Page number, my lords, page number 12, my lord.
Page number 12.
Page number 12.
I'm looking at it, call for the records.
Just
in
say the
OS
order
number.
dated so and so annexure.
Set aside the order dated so and so. You don't mention about the IA.
IA number 3, that is what.
IA number 3.
By mistake.
Agreed by the orders passed in I number 3, in OS number 1846 or 2016. The plaintiff is before this court. The suit is, the petitioner here, who is the plaintiff in the suit, had filed the suit seeking the relief of injunction
And record of damages.
and for damages against the respondent society. The IA came to be filed. Came to be filed by the defendant
On
seeking
6/4
rejection of the plaint on the ground that the defendant is a cooperative house building society. And under section 125 of the Cooperative Societies Act, a 2 months notice is required to be given. That such mandatory provision is not followed by the plaintiff. As such, the plaint needs to be rejected. The court below, considering the submissions of both the parties and also considering the order, considering the order 6, rule 6 of CPC, order 6, rule 11, and section 125 of the Karnataka Cooperative Societies Act had returned the plaint for presentation after complying the requirements of section 125 of the Karnataka Cooperative Societies Act. Agreed thereby the petitioner is before this court. Learned counsel for the petitioner submits that initially, when objection was raised, when office has raised objection with regard to issuance of notice to the had rejected the same, the court has rejected the objections of the raised by the office by order dated. What is the order dated?
Order dated, my lords, this is, no, yes, my lords,
12/8/2017, my lords.
yes. Not legible.
3-3.
3, my lords,
3-3.
3rd of
16.
3/3/16, page number 4, 2.
Three, what is the year? 3,
3/3.
something you find it here as 5/3/16.
It is written now.
It is written, my lords, this side,
Huh?
right hand side.
3/3/16 by order dated 3/3/2016 has rejected the said objection taken by the office, and the court has held that the dispute of the parties is not touching either constitution or the management of society so as to attract the provisions as contemplated under section 125 of the Karnataka Cooperative Societies Act. Then the court had granted an order of status quo. Thereafter, in the present, land council submits that now, when already court had passed an order rejecting the said case of, rejecting the office objections and given a finding that the suit is maintainable without giving notice, no notice, under the Karnataka Cooperative Societies Act, prior notice is not required. Now the court is a court ought not to have passed such an order. He submits that he has drawn the attention of the court to section 125 of section 125 of the Karnataka Cooperative Societies Act, for short, Act, wherein if anything that is touching again, suit cannot be instituted without a prior notice against a cooperative society or any of its offices in respect of any act touching the constitution, management or the business of the society until the expiration of 2 months. He submits that he has no connection with the society and neither with the constitution, the management or the business of the society. When the society started interfering with the business of with the property of the plaintiff, and demolished the structures, he has come before the court. As the relief that he is seeking is not touching upon section 125 of the Act, there is no necessity for giving any notice, and the court below had failed to consider all these aspects. He had relied on the judgment of the
Page number 5
Yes,
of
yes.
my written. Deepa Housing, first one.
he had relied on the judgments of Karnataka High Court in case of Deepa Housing Building Cooperative Society Limited, Mysore versus Vaikunta Gowda, reported in 2014 SEC Online Karnataka 12630, wherein when a similar issue fell for consideration before the court relying on the judgment of a full bench of this court has held that plaintiff in the said suit seeking for relief of partition and separate portion in respect of the suit scheduled property. Incidentally, in the pleadings, it has been contended by plaintiff that husband of first defendant and father of defendant number 2 to 5 during his lifetime had fraudulently and misrepresenting himself as only son of Srimat Ponamma had got the kata of suit scheduled property changed to his name contrary to all the norms. There is no plea against the defendants 6 and 7 except to the extent of showing that defendant numbers 1 to 5 have sold the suit scheduled property in favor of defendant number 7 under the sale deed dated 16/5/2019. Now, it cannot be said that either it is touching the constitution, management, or the business of the society and held that the notice under section 125 is not necessary. He has also relied on another judgment of this court in Srimati Hanumakka and others versus HMT Employees Cooperative Housing Building Society arising in RFA number 524 of 2007 dated 18th of July 2022. There the suit is filed seeking an injunction restraining the society from interfering with its peaceful possession and enjoyment of the suit scheduled property. There, the court has also dealt with section 125 of the Act. And the court held that from a careful scrutiny of the plaintiff, it is evident that the plaintiff has not sought any relief against the defendant society in respect of constitution, management, or business of the cooperative society. Therefore, section 125 has no application to the factual matrix of the case. In a similar lines, he relied on another judgment of this court in RFA number 1919 of 2017, dated 21st day of August 2023, in the case of Srimati Dakshayanamma versus Daiva DAIVAJNA, Credit Cooperative Society. In that judgment also, in the similar lines, an order is passed by this court relying on the various other judgments of the coordinate benches of this court. And further, he has relied on the judgment of Vinayaka Griha Nirman Sahakara Sangha Limited versus Karnataka Appellate Tribunal and others, reported in 1995 SEC Online Karnataka 33. And also a judgment of the AP High Court reported in 2010 SEC Online AP 480. Which is where the court was dealing with section 126, which is parametria with section 125 of the Karnataka Cooperative Societies Act, and where the court has held that no notice is required. Relying on a division bench of the said court, that section 126 is not attracted. Relying on these judgments, then counsel for the petitioner submits that the court below ought not to have returned the plaint, and ought not to have held that a notice is required under section 125 of the Act. The learned counsel appearing for the respondent submits that the notice is mandatory under section and notice is mandatory under section 125 CRPC and 125 of the Act. It is submitted that the society is, the business of the society is for acquiring the lands and forming the, allotting the plots and to its members. And in fact, the said land is acquired by the society. And when the vendor of the plaintiff has questioned the said acquisition proceedings, a division bench of this court had dismissed the said writ petition, that is WP number 6410 of 2006, along with WP numbers 5798 of 2006, 5795 of 2006, 5792 of 2006, 6409 of 2006, dated 21st day of February 2007, whereby the appeal filed by the vendor of the plaintiff is dismissed. Then counsel submits that, which clearly shows that the plaintiffs have no right in respect of the said property, even as contemplated under Order 6, Rule 6. A notice has to be given to the respondent, and the court below had rightly held that a notice under 125 is required. Then she had relied on the judgments of.
Apologies, Millets, may I interrupt, Millets? Kindly note that I've produced a Supreme Court order where the acquisition has been upheld.
The Honorable Apex Court has also upheld the said order in Civil Appeal number 373 of 2016 and connected appeals by order dated January 19, 2016. 2016. She has relied on the judgment of a coordinate bench of this court in RFA. In case of RFA
1966.
8th November, RFA number 1966 of 2013, dated 8th November 2022, wherein where a suit is filed against a society. That he should be declared as a owner and also sought for an order of permanent injunction against the defendant. And he has purchased a property under the registered sale deed dated 11/6/1992. That the society owns 17 guntas of land towards the west side of the suit property, and they have nothing to do with the property of the petitioner and paying fraud on the plaintiff. And the defendant is manipulating the documents. In that factual background, the court had held that in the plaint, the business of the defendant society was sustained and the same was led to be adjudicated. Under such circumstances, the trial court forming an opinion that prior notice having not been complied, the suit is not maintainable, is based on factual and legal aspects. Hence, and those are not the grounds sufficient to admit the appeal for further consideration, and accordingly, the court had dismissed the said appeal. The learned counsel has relied on another judgment reported in INR.
Millards, I wouldn't want to place my reliance on that judgment, Millards.
Because it goes against her.
Basing on those judgments, then council submits that the notice under section 125 CRPC is mandatory as it is touching on the business of the society, and the court below had rightly returned the plaint, and the plaintiff ought to have resubmitted the same after following the procedure, and the writ petition is liable to be dismissed. Next, having heard the learned counsels on either side, peruse the material non-record. In this writ petition, and the petitioner is a plaintiff. He has filed a suit for permanent injunction and also for damages. He is ascertaining, according to the plaintiff, he is the owner of the land, and the defendant society had demolished all the sheds that are existing, and he has sought for damages and also injunction. Initially, the court, by proceedings by order dated 3/3/2016, has held that the notice to the prior notice is not required, as a relief that is sought by the plaintiff is not touching upon the it do not fall under any of the exceptions under section 125 of the Act, and has granted an order of status quo in favor of the plaintiff. Now, before going into the aspect about the maintainability, it is appropriate to look at section 125 of the Karnataka Cooperative Societies Acts, which reads thus, please extract it. A bare reading of the same shows that in order to protect the interest of the society, such a clause has been incorporated where it concerns where it concerns the constitution, management, or the business of the society. The whole purpose is, if now once it says constitution, management, or the business, now the respondent tries to say that the business of the society is not is to establish is for the providing residential plots to its society. As such, this falls under the business, which this court is not able to appreciate for the reason the defendant do not have any kind of business or any kind of contact or any transactions on any of these capacities as enumerated under section 125 of the Cooperative Societies Act with the defendants. Defendant is like any other, the society is interfering with his position, who is, and because they are into business of providing plots or acquiring lands and providing plots to its members, that doesn't mean that this would fall under section 125 of the Karnataka Cooperative Societies Act. The Land Council has relied on several judgments. Land Council of the petitioner had relied on several judgments which are discussed by this court in the preceding paragraphs, which makes it clear that like a suit of this nature cannot be said that it touches any of the business management or constitution of the cooperative society, which requires a notice as contemplated under 125. It is a contention of the learned counsel for the respondent that because they have been, they have acquired the land, they have, their acquisition has attained finality by the orders passed by the Supreme Court. And in fact, an appeal is filed by the vendor of the plaintiff. All these matters are touching on the merits of the matter. It is for the defendant society to place before the court that it is a owner of the property and a suit for injunction is not maintainable. But that cannot be a ground to say that under section 125, a notice is required and on that ground, the plaintiff has to be rejected or returned. In the considered opinion of this court, first, on the ground that already by order dated 3/3/2016, the objections of the office have been rejected and the court has upheld that the court has passed an order that notice is not required. That being so, the court cannot pass such an order again by virtue of this interim order. And even on the merits of it also, no, this do not touch any of the issues that are that is the constitution, management or business of the cooperative society. As such, no notice is required. And the order dated so and so is set aside. Which year is the suit?
Yes,
So which year is the suit?
yeah, 2016, my lords.
Suit is of the
16.
year 2016. The same shall be disposed of as expeditiously as possible, but not later than 1 year.
Gotcha.
Yes.
So number 6. Vijita.
My lord, I'm the respondent, my lord.
May I proceed?
Yes.
My lord, suit for my lord declaration, my lord.
Suit for?
Declaration,
Ah.
declaring the gift deed executed by the plaintiff null and void. Thus, the,
To declare the gift deed null and void.
please, my lord,
Ah.
the litigation between the father and daughter, lordship.
Hmm.
The present petitioner is, my lord, respondent before the defendant before the trial court, my lordship.
Hmm.
My lord,
Defendant is the father.
plaintiff is the father.
Ah.
My lord, the suit is filed, my lord, on 3/10/2009.
Hmm.
Lord, thereafter, my lord, the defendant filed return statement, the present petitioner, my lord, and stated that, my lord, the court fee is meager. Then, my lord, the trial court framed issue number 3 on the court fee. Then, my lord, the trial court passed an order on 21/1/2012, my lord.
21/1.
1/2012. My lord, thereafter, my lord, the present petitioner, my lord, challenged the same before this honorable court, my lord.
No, 21/1/2000.
12, my lord.
Ah.
The same was challenged by the present petitioner before this honorable court, my lord. In WP number 5152 of 2012.
5152 of 2012.
My lord, it is produced as annexure J, my lord.
What has happened to that?
That, my lord, that the honorable court satisfied the order passed by the trial judge and directed the trial court to consider the fresh issue number 3. Thereafter, my lord, on
When was
23
this, when was this writ petition disposed of?
my lord, on 4/4/2014.
Hmm.
Thereafter, my lord, on 23/10/2017, the
Hmm.
trial court, my lord, has passed, my lord,
Another order.
or further order,
Oh.
my lord.
No. Where is that? No, court is also bothered about its, the court fees and other things.
Please, my lord.
So why is the defendant only harping on this and coming one after the other to this?
No, no,
court?
no, no. It's a,
Come to the impugn order.
my lord, it is a relevant, my lord.
Hmm.
Lordship, after that, statutory order from the honorable court, my lord, the trial court passed.
Let us see the order of this court again.
Please, my
Where is it, page number?
61, my lord. Ink page number 61.
Hmm.
My lord, the relevant para, my lord, 63, paragraph 4.
Hmm.
The undisputed fact of the case as announced. By order dated 4/7/2007, scheduled land measuring 4 guntas has been converted. The suit is filed on 3/10/2009. Once an order of conversion passed, merely because
Earlier it was calculated as a non-agriculture land.
Please, my lord.
Agriculture land, now it has to be by
converted,
non-agriculture.
non-agricultural. My lord, Subsequently, my lord, after the passing of this order, my lord, trial court has passed, my lord, order on 23/10/2017. There is no dispute that regard order. My lord, subsequently, the plaintiff has filed application to correction that order. It is produced at annexure, my lord, M.
First we'll see the first order.
Please, my lord, ink page number 70.
This is the first order.
Please, my lord, ink page number 70. My lord, paragraph, my lord, 8, my lord, relevant paragraph, 72, my lord, ink page number 72. Paragraph 8, my lord. Exhibit C1 is the order of Deputy Commissioner where it can be seen that a scheduled property is already converted. Exhibit C4 and 5 are the letter issued by MUDA and the approved plan. Exhibit C2 is the valuation certificate. Exhibit C2 is the revised list of market value of the property issued by the subdivision Mysore. The total measuring land so and so, so and so. My lord, the trial court, my lord, order to pay 2,10,925. Court fee, my lord.
Then,
Please, my lord. Then, my
what
lord,
happened?
then, my lord, ink page number 74, my lord.
We will see the IA.
Ink 74, my lord, ink page number 74. That's, my lord, filed 75, my lord. That is filed by the plaintiff, my lord. To correct the order. That was came to be allowed, my lord, subsequent order of the trial court. Ink page number 77.
What is order passed in the?
77, my lord. Reduce the court fee. By reducing the court fee, my lord, kindly see, my lord, the relevant paragraph, my lord, the ink page number.
There are two issues.
Please, my
Are
lord.
you aggrieved by the order impugned or are you aggrieved by the fact that the court cannot review its own order?
Please, my lord, both, my lord. I have, my lord, one issue, my lord, one question is, my lord, the court cannot review his own order, my lord, since, my lord, is already passed order. My lord, kindly see, my lord, ink page number 80, the order of the second order, the correction order of the trial court, my lord, paragraph 12, lordship, ink page number 80.
Okay, we will look at page number 77.
Please, my
And
lord.
please tell the court how this order is bad independently. Without the fact that, notwithstanding the fact that it is passed, the court has reviewed its own order.
Please, my lord. My lord, ink page number 80, para 12, my lord, relevant portion, lordship. Subsequent order passed by the trial court, lordship. The advocate for the defendant in the cross-examination of PWN has not denied the document issued by the competent authority.
Have you filed your objections to this petition?
No, my lord, not yet filed.
Why?
My lord, the trial court, my lord, not grant sufficient opportunity, my lord, we argued the matter on merits, lordship. The advocate for the defendant cross-examination had not denied document issued by the competent. The only cross-examination on the point that document is the valuation of the land is mentioned for record in exhibit 8. The evidence after remanded the matter of fresh education of the interim application was recorded by my predecessor in the office. The document exhibit 8 was not brought to the notice of the court during the time of hearing of the matter. My lord, it is the duty of the plaintiff, my lord, to be brought to the notice. Moreover, my lord, kindly see exhibit PI. My lord, it is in respect of, my lord, agricultural land issued by the, my lord, the competent authority. The land itself, my lord, converted, my lord, for non-agriculture in the year 2007 itself. It is admitted, my lord, this honorable court in the first round litigation, it is admitted fact that, my lord.
Exhibit P8 is in page number, ink page number 69, my lord. Ink page number 69. It is obtained from the sub-registrar office, my lord. In this, my lord, 200 rupees per square feet
1
for
minute, I'll ask you,
yes.
please wait.
Yes, my lord. Yes.
Now,
Please.
even what was the observation of this court while remanding the matter? As per the market, it is a converted land. After
Please, my lord,
conversion,
it is
has to
admitted.
be-
Please.
Now, what is the amount as for after the conversion, what are the charges and all, it has to be obtained from the registrar's office.
Please, madam.
No, exhibit P8, is it not from the registrar's office?
It is registered office.
So what, why do?
Kindly see, my lord. Kindly see exhibit P8, your lordship.
Yes,
for a
where
moment.
is it?
My lord, it is, my lord, as in page number 68.
68.
Please, madam. My lord, it is, my lord, 24/7/2006 to 29/2/2010. Kindly appreciate, your lordship.
That is what is relevant because this has taken place in the year 2009.
Please, my lord, for a moment, your lordship. 24/7/2006 to 29/2/2010. It is regarding agricultural land. I relying upon, my lord, exhibit C1, which is I brought to the notice of the honorable trial court, lordship. You kindly see, my lord, ink page number 53.
Yes.
It may not, the 2009-10, lordship, right side. Pertinent to 2009 and 10. Revised, my lord. First to, my lord, 67, it is relevant to the, my lord, 500, your lordship, it is in Kannada. It is, my lord, 500 rupees for residential purpose.
Vasati.
Please, my lord. It is residential purpose. My lord, it is, my lord, after, my lord, converted land, my lord, it is, my lord, revised cost, my lord, it is, my lord, 500 rupees for residential purpose. They are relying, my lord, only non-agriculture purpose. My lord, the order.
So how many things you will change now? What was the submission before the High Court? Agriculture, non-agriculture.
Please, my lord. They admitted, my lord, the trial court.
No, that is what is for 568 is the non-agriculture one.
500 rupees is, my lord, or for residential.
Non-agriculture at 68. 68 is a non-agriculture one.
Please, my lord.
68, what is it written? Please read. Page number 68.
Please, my lord. It is, my lord, their document, my lord. It is
It is not their doc, it is issued by the registration department.
Please, my lord.
Registration department has issued this.
Please, my lord. Registration department. has-
So what was you contended before the High Court that you only said about agriculture, non-agriculture land.
Please,
The
my
court said it is converted. So what is non-agriculture, whatever is the, as per the register value, it has to be paid.
Please,
Now,
my lord.
what is this page number 68?
68, my lord, there it is pertaining to 24/7/2006 to 29/2/2010. Issued by the sub-registrar North, my lord, it is the sub-registrar North. It is, my lord, now, my lord, it is comes under, my lord, sub-registrar South. Issued by South, the same village, my lord, the same land.
Are you not supposed to file your objections to all this when you want to tell all this to the court?
My lord,
Filing any objections, just like
Lord,
that you advance
lord,
arguments.
my lord,
And
my-
after 6 years, the court is hearing this. Had you made it clear to the court, had you filed these documents saying that this falls within the jurisdiction of so and so, this document
My lord, my
cannot be.
document, my lord, while passing the early order, my lord, my document look into, my lord, the trial judge, my lord. While correcting the judge, the order, the trial judge, my lord, notices exhibit P8. It is mentioned in the order, lordship, kindly appreciate. Ink page number 80, para 12. Ink page 80, para 12.
No, for simple question, why did you not file your counter? Why you not file your objections? And why are you raising all these objections before this court now?
No, my lord, I argued on.
Not argued. It
Please.
is not something like you do it. We don't know what you have argued. No, unless and until are you supposed to file objections to an, no, he has filed it something by way of an affidavit. When it is not maintainable and you're taking all these grounds about the sub-registrar is that and that is a vital issue.
Please.
If you have filed your objections, court could have appreciated it. And
Uh,
there is no such issue that is dealt with by the court in the order with regard to south, north.
No, there is no issue.
Because that is not the issue raised by
My
you.
submission is that, madam, kindly see, madam, ink page number 81, for a moment.
Yes.
As, my lord, as per exhibit P8, the residential sites are valued in layout as per 200 per square feet. As now it's brought to the notice of the court that the property is situated in jurisdiction of Grama Tana, Mysuru. My lord, this honorable court, my lord, while my lord deciding the earlier application, lord should kindly see. Ink page number 63.
Earlier, how much it was determined?
My lord, 2 lakhs. 2,10,925.
Now, according to you, why this is not correct? Exhibit P8.
My lord, since my lord, the land is converted, my lord, it is developer.
That's why I'm asking you, at that page number 68, please tell the court and read that whatever is and then tell the court what it is.
My lord, it is Kannada, my lord, it is.
You read it,
It
you
is,
can tell the
it is
court.
for non-agriculture purpose, my
Correct.
lord. Please, my
So
lord.
it is non-agriculture purpose and the court also, now, the same period, you are also saying about 2009, which
Please, madam.
document you have filed?
Now, suit scheduled property is converted land, my lord. This honorable court held that since it's
Correct, that
converted.
is why it is a non-agriculture.
Please, madam, non-agriculture only 200 rupees. Now I relying upon exhibit C1, my lord. I already,
That's what I'm saying, which you have not contended before.
I contended,
before.
but earlier order,
Not-
not,
Oh, in the earlier order, what you said,
Please, my lord.
it's only agriculture, non-agriculture, you said.
no, my lord, in exhibit, my
Now,
lord,
please come to the order of the learned judge,
earlier order.
writ petition,
Please,
please come to that.
my lord. For a moment, my lord, I come to that, my lord. Before rectification order, before order, I can read a lot. If you permit, I will read the order.
Which order?
Before correcting the order, my lord, which is under improved, my lord. Before correcting the order.
You have filed that order also, 23 dated 23, what is it, 23/10/2017 is also
Please,
here.
madam, for a moment, I can read them.
Please.
Please.
But what you're not understanding is, suit filed by the plaintiff.
Please, madam, for a
So
moment.
For that issue.
My
If
contention.
you really, because you do not want the matter to be proceeded to the defendant, so that's how one after the other you
No,
file
madam,
petitions
regarding
and.
the- My lord, since my lord, they have valued my lord, suit scheduled property, my lord, undervalue. That's why my lord, the issues, preliminary issues.
Let us please come to the writ petition order. I would like to see the order first. What is your contention before this court?
My lord, para 3.
Hmm.
In support of the said issue, both the plaintiff and defendant have adduced the evidence. The trial court, on appreciation of opposite overall documentary evidence and records, came to a conclusion that though the
You're
property.
reading where?
My lord, 62, in page 62, para 3. In support of the said issue, both the plaintiff and the defendant have adduced the evidence. The trial court, on appreciation of opposite overall and documentary evidence and record, came to a conclusion that though the property is situated within the corporation
So
limits.
after this, what was you have said before the court that it is converted. So
It is,
the non-agriculture
Please,
valuation, whatever it is there, that has to be taken was your contention
Please,
before the court.
subsequent order, madam, after subsequent order.
Where is the 23/10 order?
Please, madam. Annexure L, ink page number 70.
Yes.
My lord, ink page number 70, is the relevant para 8, my lord. Ink page number 872. Exhibit C1 is the order of Deputy Commissioner, wherein it can be seen that a scheduled property is already converted. Exhibit C4 and C5 are the letter issued by MUDA and approved plan. Exhibit C2 is the valuation certificate. Exhibit C2 is the revised list of market value of the property issued by the sub-registrar Mysuru. The total measurement of property so-and-so is so-and-so. The market value of the property for site for residential purpose is 500 per square feet, lordship. This is the, my lord, the observation of the earlier order, my lord. Hence, the market value of a scheduled property comes 10,880 into 500, 54 lakh 40,000. My lord, hence, my lord, fixed court fees, my lord, 2,10,925 and schedule A property.
Yes, what do you say?
My lord, as per the exhibit P8, my lord, there is a specific mention with regards to the market value, my lord. This market value, 200 rupees per square feet market value is for site particularly for site, my lord. In the second column, my lord, it is very clearly mentioned. ನಿವೇಶನಗಳ ದರ ಪ್ರತಿ ಚದರ ಅಡಿ ಒಂದಕ್ಕೆ ಮೂಡ ಖಾಸಗಿ ಬಡಾವಣೆ ಮುಖ್ಯ ರಸ್ತೆ and ಇತರ ರಸ್ತೆ. It is only 200 rupees per square feet, my lord. As per this, my lord, in page number 81, my lord, the Honorable Trial Court has made observation, my lord. May be permitted to read this, my lord.
Yes,
As per exhibit in page number 81.
yes.
As per exhibit P8, the residential site are valued in layouts rupees 200 per square feet. As now, it is brought to the notice of this court that the property is situated in the jurisdiction of Gramatana, Mysuru North Sub-Registrar Office. It is just and necessary to recall the order passed by this honorable court. The plaintiff is to calculate the court fee on the land 10,880 square feet by calculating the market value as 200 per square feet. As per the Karnataka Court Fee and Suit Valuation Act and determined by the Honorable High Court of Karnataka in writ petition number so and so dated 2014. Hence, the market value of the court fee properly
No.
comes.
1 minute,
Yes, madam.
please come to page 53. This is issued by whom? 53.
Yes, my lord. That is, my lord, same sub-registrar of Mysore South, my lord.
Sub-registrar
That is
South.
Mysore South.
Hmm. This is now, this is issued by 68?
North, my lord. Sub-registrar North.
Hmm.
Yes, my lord. This document is marked in the case, my lord, exhibit P8.
And this property is with Sub-registrar North.
Yes, my lord.
No, my lord, it is
Yes.
in the south only.
No, look at the order at page 81.
Well, kindly see, my lord, scheduled property in the plaint itself.
Now it falls. That's what the court observes.
Lord, it is wrong, my lord. It is in 53 order, my lord. It is village name. Village name is reflected in the 53 order.
What is the scheduled property? Please come to the plaint.
Please, my lord. Plaint schedule, my lord, 25, ink page 25. Ink page 25, lordship. Scheduled property, last schedule. Land bearing survey number 54/8B. Measuring 8 site out of 12 site formed out of 4 guntas, measuring east to west 80 feet, north to south 130 feet. As recited in the alleged.
There is no mention with
It
it.
is a land. It is the open land.
Yes,
as
ma'am.
per that.
It's
Now,
comes
what
under-
is this?
My lord, it is comes under Kuppaluru village. It is mentioned in Kuppaluru village. Definitely, my lord, in the 53 order, my lord, first is Kuppaluru village. It is specifically mentioned the village name. It is issued by the Bengaluru, the Mysore South, my lord,
C2 is obtained when? Date.
update date, my lord. 14/9/2010,
And when is this exhibit P8 obtained?
please.
16, my lord. 4/2/2016.
4/2?
2016.
Yes,
Sorry. Yes, my lord. 2016.
please come.
My lord, regarding my lord, the power of inherent power of the court in respect of 151. I am relying upon the unreported judgment of Honorable Supreme Court, my lord. It cannot be revoked since, my lord, he has passed. My lord, relevant para, my lord. 56.
In page number 79, my lord, the trial court has observed this thing.
Page number?
My lord, para 26.
17.
Section 151 of CPC provides for civil courts to invoke their inherent power jurisdiction and utilize the same to meet the ends of justice or to prevent abuses of process. Although such a provisions were worded broadly, this court has tempered the provision of limits its ambit to only those circumstances where certain procedural gaps exist to ensure the substantial justice is not obligated by hyper
I think this
technical.
court is speaking about a judgment and decree.
Please, my lord, this is my lord, order, my lord, the trial court may not power to review his own order, my lord. There is a provision, my lord, the remedies available to the plaintiff to my lord, the challenge, my lord, before the appropriate court.
Hmm. Yes.
My lord,
My lord, an ink page number.
since
One minute.
the trial court, my lord, proceeded, my lord, passed, my lord, since.
What is this judgment? Please get that. The,
Please, my lord, which date?
no, 1 minute. Nineteen 4 SCC 396. Or AR 1999 SC 2089. Get the judgment. Yes. 396. And there is the year 1999 SC, whichever is available. Yes. Will pass orders.
Lord,
in
in
the
English.
afternoon. Get the judgment. If you have any citations, you please place.
My lord, in ink page number 79, my lord. Trial
Yes.
court relied on reported judgment, my lord. May be
Yes.
permitted to read that.
That I have seen. I asked
Yes,
you to
my
get the
lord.
copy. Will pass orders
Please.
in the afternoon.
Yes, ma'am.
Yes. Yes.
Oblige.
Again. Anand Ramke for petitioner, KV Shyam Prasad.
For respondent.
Yes.
For petition. This is wife's petition, my lords, as against rejection of her application for maintenance under section 24 of the Hindu Marriage Act. Last occasion, your lordship were pleased to hear this matter for a while, my lords. And your lordship had asked for the information as to when, my lord, she was pursuing her studies in masters in Australia. But, that is between 17 to 2020 to 2/8/2022.
7/2/2022.
Yes. 2/8/2022.
Please tell the facts of the case.
Yes. My lord, the marriage was solemnized on 25/4/2018. And my lord, both the husband and wife are the software engineers. Earlier, my lord, the petitioner wife was working in Infosys while she was in Mangalore. Then, my lord, after marriage, she went to Australia, my lord, along with the husband. Thereafter, my lord, on 23/11/2020 is the date of separation, where, my lord, the husband abandoned the wife, my lord, in Australia, while, my lord, she was pursuing her
No,
master's.
but she didn't join by, it is on 17/2. Yes.
17/2.
Hmm.
Lord, on in May 2021, my lord, the present petition for divorce was filed in
By
MC
whom?
number
By
28
whom?
by the wife,
Hmm.
by the wife, in MC number 288 of 2021. Now, along with the petition, my lord, the IA number 3 was filed under section 24 of the Hindu Marriage Act. And my lord, thereafter, the affidavit of assets and liabilities of both the petitioner, wife and husband has been filed. And my lord, on 26/10/2021, my lord, the trial court has dismissed my application. On the ground, my lord, that the wife is.
26/10/2021.
Yes.
On the ground that?
On the ground that the wife is educated and she has a degree. So therefore, my lord, she is capable of getting a job, and so therefore maintenance need not be granted. And the second ground, my lord, is that the husband claims that he has got a order of divorce from a court in Australia.
When?
Lord, that is now produced, my lord, along with the objections to the present petition.
Ex parte decree.
Yes, my lord. It appears to be so, my lord, on 21st of June 2022. Subsequent. This is produced as.
They are separated in May 2021. Yes, madam.
Hmm. Hmm.
So I filed
What
the
is the,
petition
what is the
first,
finding of the court on this aspect?
my lord.
What is the finding of the court on this aspect?
The finding, my lord, is that there is already a decree granted, a decree, at that time it was pending. So there is a proceedings before Australia court. So therefore, the wife has not approached the court in Australia to get maintenance. That is what the
Has she
court,
contested?
yeah, she has not contested, my lord. She has not contested.
But upon my lord, she is fully aware. They have filed the petition here not to pronounce the order in the Australian court.
There was
Restraining
an
her from
anti-suit
participating in the
injunction as well.
proceedings. And she,
Where is she working?
she is Australia.
She is
Both are
now in
Australia
Australia. Both
only.
of them are in Australia.
When you, both of you are living in Australia, why should you come and file a
It's
petition in
only
India?
prestigious fight of the father of the petitioner, my lord. So taking the general power of attorney from daughter is fighting here
I can
unnecessary.
understand. Wife is in India and husband is in Australia. So she had filed a petition here. Wife is there. Both of them are living there. Why she should contest the petition here? Court has rightly said, why did you not file an application there itself when you're aware that the pending proceedings are there?
My lord, because the marriage is
the-
solemnized in Mangalore. Marriage is solemnized in Mangalore. And my lord, as on the date of filing the petition, my lord, they were also not the citizens of Australia. They had got the citizenship subsequently. My lord, after the petition was filed. And thirdly, my lord, section 13 of the CPC is very clear as to when, my lord, a foreign judgment is conclusive.
No, that is a different
Yes.
aspect. Whether it is
Yes.
binding or not, we will, that will be
Yes.
decided.
So
in the
therefore,
due
my lord,
course.
I have an option, my lord, to file a petition in.
You have an
Yes.
option, but.
So I have
but-
exercised it.
No, why should you? It is not that whether the judgment is binding or not is a different aspect. No, on the face of it, all these shows you living in Australia, as on, no, the husband is also living in Australia.
Husband has got the citizenship of Australia as well.
Uh,
Lord, I am presently, my lord, I am working in Australia.
Yes, and
I'm-
you have been there right from 2018, 2020, or
See,
20, after
Lord,
2018.
I went along with my husband to Australia. Thereafter, I pursued my master's. Now, my lord, when I was pursuing my master's, he abandons me in the year 2020, November 2020. Thereafter, I completed my master's.
What was that application filed? That judgment should not be pronounced.
Yeah, that
But
also.
I filed an
that suit also
anti-suit
dismissed, my lord.
injunction application before the trial court.
Hmm.
Lord, that came to be
When-
allowed.
When did you file it?
My lord, that was filed and orders were pronounced before the Australian court passed the orders. I have a copy of the order.
No, according to you,
Yes.
when did you know about the pending proceedings in Australia?
My lord, when he filed the written statement in the
When was it
present
filed?
petition.
When was it filed?
That is, my lord, in September 2021.
So,
My lord, after I filed the petition in Mangalore in India, my lord, thereafter he filed a petition in Australia. There is no dispute on that. Lord, that is, my lord, what the court has observed. Trial court. This
you
application
have
order has
received the
become final.
notices from the court in that?
Pardon me, my lord.
You have received the notices from the court?
Lord, that I do not have specific.
No,
I might have.
that is why they filed a petition in Mangalore stating that
Lord,
not to pronounce
petition
the
in
order,
Mangalore
not to
was filed
participate.
first. Petition in Mangalore was filed first.
First,
He received the notice in the Mangalore petition, and then as a counterblast, my lord, he filed the petition in Australia. The husband filed.
So when you receive the notices from the court and you are a resident of Australia, are you not supposed to bring all this to the notice of the court, and are you supposed to wait for the decree to be passed?
Lord, I need not consent, my lord.
No,
in
it was a
Australian
contested
court-
one.
Pardon me.
The contested one.
No, it was not a contested
That's
one.
what I'm saying. You didn't appear before the court.
No, I did not appear because I have already filed a petition before, my lord, the court in Mangalore, and I also filed this application, my lord. Your lordship may kindly peruse the order, my lord, which I have furnished. This is passed, my lord, on 3/6/2022. Now, my lord, the court in Australia appears to have passed an order on 21/6/2022. Before that, on 3/6/22 on IA number 3. This is filed, my lord, 39(1) and 2 and section 151. Para 3, my lords. The materials placed before this court, prima facie disclosed, page number 3, para 3. The present petition, my lord, was filed on 28/5/21. And lord, husband filed on 19/8/21.
para 3, my lord, of the said order. I filed the petition of divorce on 28/5/2021. And then, my lord, the defendant has entered appearance in the said case. The plaintiff has also produced documents which prima facie show that defendant has filed an application on 19/8/2021 before the Federal Circuit Court,
No,
Parramatta, Australia.
as of now, there is no requirement.
No,
As of now, there is no requirement of maintenance to the wife.
no, my lord, subsequently she has got a job. My lord, all that I am saying is, my lord, as on the date when she filed the application, she was without a job.
No, the purpose of interim application and deciding the maintenance at this point of time, it has no significance now.
No, it does have a significance, my lord.
Because
I am entitled for maintenance, my lord, from the date of the application.
Those aspects, let the court decide during the course of evidence, that I will leave it open.
And so that would be insofar as permanent alimony is
Not permanent alimony, about you were you have at that point of time, what is that you have spent and all those things.
My lord, let the family court redecide this application. My lord, the application that is
Why
presently
should-
filed.
No, and as of now, whatever, the whole purport of section 24 now has lost now. Because you are employed, you do not require any amount as of now.
No, I'm not saying
Ultimately-
that. My lord, I'm not saying that I do not require any amount at all, because that aspect has never come up before the court. Now, my lord, as on the date, my lord, when this order was passed, I did not have an employment. Then, my lord, now, my lord, during the pendency of this case, and my lord, I have to sustain myself. I have got an employment because I had to sustain because he was not paying me any maintenance. So, therefore, my lord, my application for maintenance looked at from that angle, my lord, will not become infructuous. My lord, that is my submission.
It's not infructuous. Now, the whole purpose of granting maintenance, now, till now, it has not been granted. Now, for granting the maintenance, no,
Lord,
it is
my
not.
submission is the trial court has rejected my application only on the ground that I'm capable of getting a job. It's not even their case that I had a job.
That
My
will
lord,
be decided.
he is capable of getting a job. Your lordship may kindly see, my lord, the order. My lord, my humble submission before your lordship is
Yes.
that is not a ground, my lord, which the Honorable Supreme Court has reiterated time and again. In Manish Jain's case, followed in
But
Rajneesh versus
unfortunately,
Sneh.
the Honorable Apex Court in several other cases have taken the other view also.
That is true. That is true. That is, my lord, when the court comes to a conclusion that the wife is employed or that she, with the employment and with the salary that she has, she is capable of maintaining herself in the very same standard which while she was during her marriage. So that finding is not given. Your lordship may kindly see at para 18. Para 18 at page 120. Now, my lord, let my learned friend produce all those documents, or let the husband and wife file their, my lord, revised affidavit of assets and liabilities
That
as to what is the.
This exercise, this court need not take.
Let the trial court perform that exercise.
But not as an interlocutory application, please.
Because the application itself for interim maintenance.
The MC,
There are two judgments which I would like to rely upon.
Yes, please pass on.
Yes.
Agreed with the orders passed in I number 3 in MC number 288 of 2021, dated 26th October 2021. Whereby the wife's application for interim maintenance was rejected by the court. The wife is before this court. The facts of the case are that the wife had filed, the marriage had taken place on 25/4/2018. Keep it here, 25/4/2018. The parties, after that, they left to Switzerland, Australia. In Australia, on 23/11/2020, the wife had to leave the matrimony, had to leave the home. And in the month of May 2021, she filed a petition for divorce in India. Husband had filed a petition for divorce in the month of June before the courts at Australia. The husband has filed his written statement or his objections, wherein he has mentioned about the said petition filed by him, which was very much within the knowledge of the wife. It is a case that she is pursuing her master's there, and she was thrown out of the home. And the husband has to maintain her, and she has sought for maintenance at the rate of Australian dollars 2,000. That is rupees 1,14,000 per month. The courts at Australia have passed a decree of passed a divorce, an order of divorce on
21/6/2022, I produced this.
21/6/2022.
In that also, they
Before
mentioned,
that,
if you want any day, the monetary claim, you can claim it in the, that's also mentioned in the divorce order. That she has not exercised.
what did they say?
See, my lord, I produced an NHRB. A divorce order be made, such a divorce order is to take effect thereby terminate the marriage on 22nd July 2022.
Where is that? 1 minute.
Notes,
It's to the statement of objections filed by my learned friend.
page number 8, my lord,
Page 7 and annexure B.
7 and 8.
Oh,
At the notes portion, your lordship kindly see,
where is that? Page number?
8, notes portion. That's a divorce notes portion. Yes.
Family law divorce order.
Yeah.
Ah.
Second page, that is second page, your lordship kindly see the notes portion.
Huh.
If a party to the marriage proposes to make an application to the a court exercising
Order
jurisdiction.
dated 21st June 2022. A divorce was granted by the family courts at Australia, wherein in the note, it is mentioned that if a party to the marriage proposes to make an application to a court exercising jurisdiction under the Family Law Act as to property or as to the maintenance of that party, such application must be made within 12 months from the date upon which the divorce order takes effect. After that time, such an application cannot be made without first obtaining the leave of the court to do so.
By this time, I already filed this application here,
The
maintenance.
a divorce order which has taken effect may revoke or otherwise affect the operation of the will of a party. Before this order is passed, an IA is passed before this court and IA number 1 is filed under section 13 of the Family Courts Act. No, where is that? IA number 3 is filed. Thereby, the wife had sought an ex parte temporary anti-suit injunction restraining the defendant from pursuing further with the divorce petition number PAC 4361 of 2021, pending on the file of the Federal Circuit Court, Parramatta, Australia, until the objection to main petition or the objection is filed. This order came to be passed on 4/6. What is the date of order? 4/6/2022.
3/6.
3/6/2022. And the Australian courts have passed an order on 11, what is the date? Just now?
22/6.
On 22/6,
Sorry, 21/6.
on 21/6.
That judgment also, subsequently judgment raised in OS number 13/2022 and suit dismissal
And
by the trial court.
21/6/21. Later, the said judgment was questioned.
By the OS 13/2022,
Finding OS number
13/2022
13/2022.
by the petitioner herein,
Hmm.
and judgment was pronounced on 14/8/2023.
On 14/8/2023.
Yes, my lord.
On 14/8.
Any of the divorce passed in Australia court, this may not
On
serve.
14/8/2023, the same came to be dismissed. The court that the separate suit is not maintainable.
Yeah.
And
But-
that the same can be questioned in the divorce proceedings.
Divorce.
Such a decree is not here.
Yeah, here also.
Divorce proceedings, such a decree is not maintainable.
Maintained.
I mean, it's not binding on the party.
Yes.
No,
yes.
observation is para number 10, your lordship kindly see.
Hmm.
It is not in dispute that already I said PSC 4361 of 2020 has been disposed of by the Federal Circuit Court, so and so Australia.
Point for the suit is filed for an order of prohibitory injunction restraining him to pursue the said matters. As the said suit is already, the said divorce proceedings are concluded.
Sure.
The court has felt that the suit is infructuous.
Yes.
Accordingly,
That is not
dismissed.
challenged. That is not challenged.
Accordingly, the same was dismissed as infructuous.
And this is final.
The court, by order impugned, had dismissed the application that's filed by the wife seeking interim maintenance on the ground that
para 18.
That a plain reading of section 24 of the Hindu Marriage Act makes it clear that if it appears to the court that the parties to the proceedings has no independent income sufficient for her or his support and the necessary expenses of the proceedings, the court may, on the application of any one of them, order the other party to pay the expenses of the proceedings and for the reasonable maintenance during the pendency of the proceedings. It is also observed that both the husband and wife failed to comply with the directions laid down by the Honorable Supreme Court in Rajneesh's case. Both of them did not opt to file their personal affidavit of assets and liabilities as required as per the judgment of the apex court. The GPA holder of the petitioner, that is father, and respondent filed the affidavit of assets and liabilities
Through his father only.
respectively by affixing their signatures to the said affidavit. Then the court felt that this is not in compliance with the orders of the apex court in Rashid's case. The other aspect the court felt that to be considered is whether the wife is in need of financial assistance from the respondent for her maintenance. According to her, she has no independent income of her own and she is pursuing a master's degree in information technology in Australia. The petition is BE graduate and she was working for Infosys while she was in India. The petitioner was employed and she had earnings as long as she stayed in India. Now she is permanently residing in Australia. It is a case of the husband that he maintained as long as she stayed with him, providing for her with reasonable comforts, and he moved out from the rented premises in which they lived together at Australia at the instance of the petitioner, leaving the rented premises for the exclusive use of the wife, and he paid the rental as long as she stayed in the rental premises. And thereafter, she surrendered the rental premises and shifted her residence at her choice. The respondent produced the husband produced a photocopy of Commonwealth Bank statement of the petitioner in Australia to show that on 24/12/2020, $1,500 Australian dollars was debited from the petitioner's account to the account of her father, and also produced a copy of the statement of accounts pertaining to the petitioner's father's HDFC bank account to show the amount credited by the wife to her father's bank account. And the wife in August 2020 itself opened a separate bank account and started residing separately in a different accommodation. And also he has furnished the address where she is residing. That the court come to the conclusion that the evidence placed before the court leads to the inference that the wife is well qualified and she is capable of maintaining herself. It is not the case of the wife that she cannot secure the job for maintenance at Australia, even after best possible efforts. The job opportunities in Australia, that too for a BE graduate person, shall also be taken into consideration. The wife becomes entitled for maintenance if she is not in a position to maintain herself. The wife claims that she's earning by doing project work in Australia besides pursuing her studies. The respondent has not produced any documents to show that the husband has not produced any documents to show that the wife is having earnings and she's capable of maintaining herself. Only that the wife had transferred money to her father's account. The wife is also not produced a bank statement, which is holding at Commonwealth Bank, Australia. The court observed that the wife had suppressed information relating to her bank accounts, which she is holding at Australia. Hence, the contention of the petitioner that she is not capable of maintaining herself and she is not having sufficient income for her maintenance to meet her litigation expenses cannot be accepted, and accordingly dismiss the petition. Court officer.
Yes.
The land counsel appearing for the petitioner submits that as in view of the differences between the parties, she has to move out of the court, out of they were separated. And she's studying and she's not working. At that point of time, she requires maintenance from the husband. It is submitted that the husband has failed to take care of the wife and instituted a case before the family courts at Australia. And in spite of an order by the courts here restraining him from pursuing the matter, still he had obtained they have obtained a divorce from the court. Then he had relied on the judgment of the Honorable Apex Court in Rajneesh versus Neha. Which para?
No, Rajneesh versus Neha, paragraph 71, 79, 81, and para 90.
79.
79, 81, and then para 90 to 90.5.
He had relied on para 79,
81,
81,
then 90 to 90.5.
92 and 91.5.
90, 90 to 90.5. 9.
Write it on a paper.
Yes.
He has relied on so and so paragraphs and submits that the said order passed by the court with regard that the wife that she's capable of earning cannot be a ground for not granting maintenance. One more judgment is there or is the only
Yes, one moment. Manish Jain versus Akanksha
You've
Jain.
passed on that?
Yes, I have.
I think in that,
It's 2017-15.
and he had relied on another judgment of the Supreme Court in case of Manish Jain versus Akanksha Jain, reported in 2017, 5 SCC 801.
15 SCs.
15 SCC 801.
Paragraph 12 and 16.
Paragraph 12 and 16 extract. Facing on these judgments, and counsel submits that the court below ought not to have take that slip, ought not to have granted give it to him. Ought not to have granted, ought not to have dismissed the application filed by the wife seeking maintenance. Then counsel for the respondent submits that the wife was while she was in America, she was in Australia. He had been paying for the charges for the accommodation, and she suddenly vacated the same and shifted to some other accommodation. And they had also filed the document, the evidence before the court that she has transferred an amount of $1,500 to the account of her father. It is submitted that when she is aware of the proceedings that are pending before the courts at Australia, she has not even taken any steps to appear before the court and submit the same before the court, all these aspects to the court. It is submitted that after the divorce decree is passed, even in that said decree also, it is mentioned that she can ask for maintenance before the said courts. It is submitted that a person, the party who is residing in Australia, and both the parties are residing in Australia, the wife filing a petition for divorce in Bangalore through a GPA holder clearly shows the intention of the wife. It is submitted that the court had rightly observed that as per the judgment of the apex court, the relevant documents are not filed, and the court had rightly refused the request of the wife for interim maintenance. Next, having heard the counsels on either side, there is a material on record. In this case, both the parties, both the wife and husband are educated. Both the wife had completed her BE, and while she was in India. They were married on 25/6/2018. While they were in India, she was working in Infosys. Later, they left to Australia. In 23/11/2020, they have separated, and she started her education, that is her master's, on 17/2/2020, and she completed it on 2/8/2022. It is a case of the husband where it's recorded by the court below that the husband had continued. She stated he left the rented premises where they were staying together, and she continued to stay in that premises, and she continued to stay for some more time, and till such time he was paying the rent. Thereafter, she left that place, and she took her own accommodation, and she was paying for that. And he has also placed the evidence before the court that she has transferred an amount of rupees $1,500 to the father's account. Thereafter, she had her separate account. Unfortunately, if the party wants to have maintenance seeks maintenance from the court, they have to follow the procedure as laid down with the Honorable Apex Court in case of Rajneesh versus Neha. Unfortunately, in this case, the wife or the husband had not filed their respective bank accounts, the details and all the relevant as required as per the judgment of the Apex Court. And the manner in which these proceedings are pursued by the parties, and when both the parties are in Australia pursuing the litigation in India, and also filing several petitions to stall the proceedings in Australia, and without even pursuing them, even submitting and letting the Australian courts, even after notice of the said proceedings, to pass, letting the courts at Australia to pass a final order, pass a judgment and grant the drivers. It all appears that both the parties have not come before the court with all the actual facts, and also the petitioner could not satisfy the court with regard to her requirement and the necessity of passing an interim order. Now, when this matter is coming up for hearing before this court, where in 2024, it is also not in dispute that she is working. The contention of the council that whether she is qualified or not, and it is a duty of the husband to take care of the wife, and there are judgments of the Honorable Apex Court. The judgments, there can't be any straitjacket formula. It all depends upon the facts and circumstances of each case. The proposition of law, just like that, cannot be applied to all the cases. And coming to this case, if at all the wife is in requirement of the amount, and she has no she is not able to maintain herself, then she could have filed all her bank statements before the court, and could have impressed upon the court about the requirement as per Section 24. Considering all these aspects, and particularly the fact that in 2024, at this point of time, and considering the interim application for maintenance cannot be, during the court can decide the said issue, that whether any amounts that are basing on the statement that are filed before the courts, basing on the evidence before the court, if it is established before the court that the wife is not in a position to maintain herself even from that day till she got the job, basing on that, the court can pass appropriate orders while deciding the final application itself. As in this case, this court feels that looking at the overall factual matrix of the case, the requirement of deciding this interim application is no more survives. Accordingly, the writ petition is, with the above observations, the writ petition is disposed of. Yes.
My lord, in case of change circumstance, my lord, liberty may be to file an application.
In
case
case
of-
of anything, no, what will happen is, no, there is no end to this MC. Again,
Yes.
you're again, again another round, again you come back.
Yes.
Let it attain finality. No.
But one aspect, that bank statements were filed, which is on record.
No,
Both
no.
of us have filed
No,
bank statements.
another bank
Not
statement.
as per, as required under.
The GPA holders have filed. Yes.
May I
Yes.
make a mention, Lord, serial number 22 is for withdrawal of the writ petition on account.
20?
22.
For the respondent, my lords.
Joint memo is being placed on court. The petitioner.
22,
Authorized
both the
representative-
petitioner, no mentions. Both the petitioner, both the counsel for the petitioner, the respondent present, a memo is filed seeking to both the counsels, both on behalf of both the parties, a memo, a joint memo is filed seeking withdrawal of the writ petition, stating that pursuant to the order dated 27/9/2022 passed by this court, the parties have negotiated and discussed the matter at length and have reached a commercial understanding. This, and in view of the said developments, they undertake to withdraw the suit bearing OS number 244. No, this is not just a withdrawal.
My lords, the memo is in the.
No, in a matter, it is like a compromise.
My lords, matter settled out of court, the memo is.
No, we'll not record all these joint memos and all. If it is, we can't record before, with the advocates, there should be parties.
My lords, the counsel-
Parties have signed, my lords.
Parties might be signed, might have signed. The court has to know from the parties. If I have to record it saying that it is a compromise, just if you say that the parties have settled the matter, then we'll not consider any of this.
In terms of
If
the.
it has to be considered, both the parties have to be here.
My lords, the authorized representative of the petitioner.
What
is
about the
present.
respondent?
Respondent is not here, my lords. It's
So
not
then
before the court.
We'll not record all this. We can only say that it is stated that you give a memo, that a memo is filed before the court stating that the matter is settled outside the court and hence the writ petition may be dismissed.
Otherwise, if the respondent can keep their party present in the.
Yes.
Not in the afternoon, I need some time.
My lords, my
Well-
party has traveled from Calcutta, visit. before.
What can I
My lords,
do?
If they
What
will
can
be
I
free
do?
soon.
Suit dispose of in terms of the memo, my lord, that can be the order.
That can't be done. It should be, it can't be just like that. How can both of you advocates say something, how can we? And if it is a compromise, we have to ask the parties whether such a now compromise is there.
And in fact, that was also indicated and that's why both parties have signed it with the seal.
Might be,
also.
might be, but
That
unless and
was
until,
had on Thursday.
I'm telling
Please.
you, like, if you want it, that you want to withdraw, you can withdraw at liberty. But if it has to be recorded, that so and so party should be here.
Of like, that may be had on Thursday if the rest.
Thursday?
Also.
Thursday,
Your Honor, serial number 33. Your Honor.
mentions please.
ನಾಳೆ ಮತ್ತೆ ಇರಲ್ವಲ್ಲ finance ಕೊಡ್ತೀವಿ. ಮೆಮ್ಮ ಆ ಕಡೆ ಇರುತ್ತಲ್ಲ, ಪುಸ್ತಕ ನೋಡಿದ್ರೆ. ಆಮೇಲೆ LKG ಅಂದ್ಬಿಡಿ.
ನಿಮ್ಗೆ ಬರೆಯೋದು ಬರ್ತಿದ್ವಿ.
ಆ ಕಡೆ ಇರಲ್ಲ, ಪುಸ್ತಕ ಅಲ್ಲಿದೆ ನೋಡಿ.
ಹಿಂಗೆ ಅಲ್ಲ
ಮೇಡಮ್ ಮ್ಯೂಟ್ ಮಾಡಿ. ಇವ್ರು ಮೆನ್ಷನಿಂಗ್ ಏನಿಲ್ಲ ಕರೀತಾರ.
Hello? Hello, court officer? Hello, court officer? Hello, court officer?
Income, my lords, according to the MC, my lords, is around 80 to 90,000 rupees is the income, which also includes extra properties and all, my lords. So on that basis, 28 lakhs was granted by the in the MC case, my lords. And before that only, we filed interim maintenance for day-to-day basis, my lords,
Interim maintenance is 50,000 per month.
which was not granted. We only sought for.
I'm asking you
Yes.
how much you sought.
So 50,000. We sought
Yes.
for 50,000, my lords. There was no order till now and it got stayed. The only amount that has been given is 7 lakh rupees from the MFA case.
What do you say?
Once it has been completely adjudicated, the party cannot make the shift to one to the next under the area, under the one. That cannot be done. That is why last petition, similar questions have been Supreme Court in the last petition about that. Whether after granting of the permanent decree competition, whether it is available for the wife to claim a maintenance under let's say area, similar. MFB is spending in that code also.
That's what must be there in the file.
Maintain the details different from permanent area. That is what we should do.
Now, when you obtain that order, when is the order in this writ petition passed?
It's a 31/5/2022. No writing application.
No, 31/5/2022. They have filed that petition for maintenance much before the MC.
But the fact remains, even they are entitled to permanent territory includes all the maintenance. Whether it can be under the 125, whether it can be under the Leave Act, the section stipulates under 127, what all the maintenance can be granted, can be adjusted in the civil code. Section 25 of the Union Marriage Act also stipulates that in changing circumstances, any decree that could be passed or an interim maintenance that could be passed, it can be adjusted. Therefore, once again, I am going, facing a trial would not arise because already a permanent right. Now, they have not filed an application before the adjustment court seeking this amount. Nor they have filed before this court seeking vacating of the state of the interim order. Nor they before the trial court against 125 application, the interim maintenance application was decided. It was filed at the time of this evidence. Therefore, the word contemplated under section 125 that a person with a restricted device does not arise at all. That is why I pointed out the Supreme Court.
That's not there in the file, it seems.
That's one submission, my lords. Regarding section 127, my lords, when it can be applied. My lords may look at 127 and its wordings, my lords.
Yes. What is that? Give it to him. Yes.
Yeah, court said decree, you had in the present case, paragraph identity. In the present case, the matrimonial proceedings initiated by the respondent wife seeking resolution of marriage innovation. When that decree, the resolution was passed in the following effect. Next year, paragraph. The aforesaid decree passed on 22 2013 presently subject matter challenge before the High Court in Pacific 26. This is also said. Before so it's that is still pending consideration before the High Court. It must be stated that in sometimes 2005, an application.
Yes, I've seen the judgment. Yes,
Therefore, the court says it's a reverse.
I've seen in the last paragraph.
Reverse.
Hmm.
It is an interim application. Okay, case where we have permanent temporary. The courts have decided, matter is subsidized before the application. They can file an application seeking modification of that order. The present prosecution granting the interim does not happen because all of the law is finished in the law. It has to be adjusted. That's the if the court not reduce it, even if it is enhanced, but I'm bound to pay.
No, what just now the submission which you made is something which is in your favor. You said there's some amount that is granted that can as well be adjusted by the MFA court.
But so far as the permanent ceremony is concerned, this court will have seized of the matter. What prevented, I'm asking you a question for myself. What prevented them to file an application and brought to the notice that see all the proceedings have been stayed by the court. That's what the 7 lakhs which have been granted is not sufficient for me. Kindly release some more amount. Having, taking the sufficient security, then.
Lords, for that submission, my lords, the object of the permanent alimony is, my lords, for the future of the wife, my lords. In the future, she should not suffer from any helplessness, my lords. So that is the reason, my lords, permanent alimony is granted. Now, in any case, my lords, I seek permanent alimony and withdraw some more amount from 28.
Future itself is secured.
My
I
lords,
mean, do you mean to say that your present should be secured by this?
my lords, but there is no reason, my lords, because of the reason of criminal miscellaneous, my lords, have not made any application before this court. Now, whether that will give the liberty, my lords, to
How
say,
can it be? No, this matter is stayed long back by this court. In that case, the only remedy available to you was to approach the MFA.
yes, my
MFA
lords.
court.
But before that only, my lords, we had filed criminal miscellaneous.
This is a writ petition of
2022, my lords. Yes.
In 2022, there was a stay.
Yes.
Because of that, the criminal miscellaneous petition, you cannot pursue.
Yes, ma'am.
In that case, in the pending MFA, if at all what you demonstrate or what you try to submit to the court, that there was a dire necessity for the wife,
Yes.
would have done it before the MFA.
Lords,
court.
my lords, this case, my lords, criminal miscellaneous was at the stage of evidence.
We are on the point.
Yes.
Why you didn't do anything from 22 to 24 when that necessity is there?
Yes. Lords, that we don't know, my lords, because the client also did not approach us, but my lords,
So it is not about you doing
Yes.
that. Your client,
Yes.
if your client has the necessity, she would have come to you.
yes, my lord.
Then you would have moved an
That
application.
is why, my lords, we moved this matter for final disposal, my lords, so that at least this matter at least would get seized, my lord. My lords, one submission, my lords, regarding section 127, my lords. The application that I filed under section 127 is not at all maintainable, my lords. Lords may look at the wordings of section 127. On proof of change in the circumstances of any person receiving under section 125 a monthly allowance for the maintenance or interim maintenance, or ordered under the same section to pay monthly allowance for the maintenance or interim maintenance to his wife, child, father, or mother, as the case may be, the magistrate may make such alteration as it thinks fit in the allowance for the maintenance or interim maintenance, as the case may be. Lords, in our case, my lords, there is not even an order that has been passed to seek alteration in the case, my lords. Read 2, where it appears to the magistrate that in consequence of any decision of a competent civil court, any order made under section 125.
What is happening to the business? No, CRPC is not there, GNWC Act is not there. Yes.
My lords may look at 127, my lords, and 127 clause 2 as my friend replied, where it appears to the magistrate that in consequence of a decision of a competent civil court, any order made under section 125 should be cancelled or varied. He shall cancel the order as the case may be, vary the same accordingly. My lords, even in case of clause 127 clause 2, there is no order under section 125 to vary or cancel because of change of circumstances as per the competent civil court's decision. Now, when an application itself cannot be made in under 127 of CRPC, then my lords, seeking of quashing of closing of this criminal case, my lords, does not arise, is my stand, my lord.
Yes, what is your response to that? No, what your response to that is submission with regard to the maintainability of your petition? No, first of all, before knowing the Supreme Court judgment, we have to see the provision and how the provision empowers you to file such an application.
Pass any order.
Let us, please, you filed this petition under 127. Please read 127.
Receiving under section 125 of the manner, doesn't for the maintenance or information or order in the same section to pay a monthly allowance for the maintenance or increment to the wife child.
So, to invoke 127(1), there should have been an order of maintenance under 125 in the very same proceedings before by the magistrate. That is one. Now let's see to what you are referring to.
Where it appears to the magistrate that in consequence of a decision of a competent civil court, any order made under 125 should be cancelled. Any order. The word does not refer to a only and maintenance.
Any order made under 125.
Even taking a cognizance is also an order.
Please read it again. Please read it again.
Where it appears to the magistrate that in consequences of any decision of a competent civil court, any order made under section 125 should be cancelled or varied. He shall cancel section.
So, under 127(2), he can cancel the order. That is provided there should be an order.
Correct.
Here, there is no order in your case.
Yes.
Then,
Cancelled. Cancelled the order or as the case may be, varying the same accordingly. Where any order has been made under section 125 of the woman who has been divorced by or has obtained the decree from her husband in magistrate shall satisfied with the woman for the next civil court. At the time of making any decree for recovery of a maintenance or a dowry by any person to whom monthly allowance for maintenance and the interim maintenance or of them has been ordered to be paid under section 125. The civil court shall take into account sum which has been paid to or recovered by such person.
now please come to the application that is filed by you.
Page number 34, my lords.
Yes. So ultimately, the prayer that you sought is? Therefore,
Dismiss the
please to dismiss the, where is that?
Page number 36.
36. The only intention of the petition so-and-so in the name maintenance from the applicant so-and-so and by misusing. Petition has not come to this court. Pending, hence the relevancy of this petition has extinguished. May please to dismiss the petition.
For that, my lords, the same grounds we have filed objection also on that 127 application is not maintainable. In the very next page, my lords. The same, my lords, 127 is not at all maintainable is our stand before the trial court also. My lord.
Please come.
Double maintenance cannot be awarded once it has been awarded.
That is not your case at all.
It is
No,
not.
we are impugned, what is impugned before this court is an IA filed by you stating under 127 so-and-so. Now, what this court has to consider is whether what is the scope of section 127 and other provisions, can such an application is maintainable. When once the application is not maintainable, whether your stand of double maintenance can be awarded or not is one which is on the merits of the matter. That is, you're always at liberty. You're always at liberty. Yes, please come. Agreed with the order passed in I number 7 in criminal MC number 9 of 2019 dated 16th May 2022. The husband is before this court. The parties are referred to as so and so. The wife had filed MC number 9 of 2019 seeking maintenance under section 125 CRPC of an amount of rupees 50,000.
50,000.
50,000 per month. And the matrimonial proceedings, that is MC number 384 of 2016, is filed by the
Wife man.
MC also,
MC also.
seeking dissolution of marriage by the husband, seeking dissolution of marriage. This application is filed in the year 2019. The court had passed in the MC by order dated 18/6/2022. The court had dissolved the marriage between the wife and husband and granted permanent alimony of 28
Lakhs.
28 lakhs. Agreed thereby, both the wife and the husband had carried the matter before this court. In the MFA filed by the husband, this court had granted the interim, the granted stay on the condition of depositing 7 lakhs of amount, which the wife is permitted to withdraw. This criminal MC, which is much prior to the filing of, prior to the disposal of the MC, when it has come up before the court, the husband had filed a petition under section 127 of the CRPC, wherein it is the stand of the husband that where are that IA 30?
Page number 34 minutes.
Wherein he has stated about the MC and the order passed in the MC and the subsequent appeals filed by both the parties, and also the stay order that is granted by the court, where under 7 lakhs deposited by the husband. It is this case that the wife had failed to disclose the permanent alimony of an amount of rupees 28 lakhs granted by the court. In spite of a notice receiving in MFA, no appeal is preferred by the wife. It is this case that the wife who had been granted permanent alimony under section 25 of the Hindu Marriage Act, under section 25 of the Hindu Marriage Act, cannot be granted maintenance under section 125 CRPC, and accordingly prayed the court to dismiss the petition. Then to that, the respondent herein, that is the wife, had filed her objections, wherein it is stated that the husband is duty bound to maintain the wife, and the wife had to undergo medical treatment monthly, and she is depending on her parents, and she has to maintain herself pending the MFA. The court below, by order impugned dated 16th May 2022, had dismissed the petition filed by the husband. No, I am recording it. The court had dismissed the petition. While dismissing the said petition, the court has observed that whether after the grant of permanent alimony to the wife under section 25 of the Hindu Marriage Act, a prayer can be made under section 125 of the CRPC over and above what is being granted by the court under section 25 of the Hindu Marriage Act, will be decided by the Marriage Act. And remove that. The court has observed that the judgment that are relied on or in a different facts and circumstances. And the court, in the judgment in Rakesh Malhotra's case, the court has distinguished the said judgment of the apex court on the facts of it. And court observed that in the incident case, the wife had already preferred the application under section 125 CRPC, and the same is pending order granting permanent alimony is passed, and the same is under challenge before the appellate authority. Accordingly, the court held that the petition filed by the petitioner under section 127 of the CRPC is dismissed. The aggrieved thereby, the husband is before this court. Learned counsel appearing for the husband submits that he had relied on section 127, which is applicable to you according to you. He relied on 127(2), and basing on that, he submits that as per section 127(2), he can maintain an application, and the court had to consider the scope of maintaining this application when the permanent alimony is granted, when the rights between the parties are decided, and the right of the wife for a full and final settlement is already decided. So at this point of time, the 125 the proceedings that are pending before the court are not maintainable. He submits that the judgment of the apex court in Rakesh Malhotra's case, the court below had failed to consider in the proper perspective, and the writ petition is liable to be, and it is also submitted that when the MFA is pending from 2022, at no point of time, the wife had not moved any application before the court seeking interim maintenance. That itself shows that she is not seeking any amount, withdrawal of any amount for her maintenance. That itself shows that she has no a pressing need and necessity for the amount. He submits that as the writ petition, the MFA is pending, any amount that is required, an appropriate application ought to have been made. And these kind of before different forums, the matters cannot be pursued by the parties. Next, and the writ petition is liable to be allowed. Next, learned counsel appearing for the respondent submits that the application under any of section 120, any provision from 1 to
120, 127, 1 to 4.
From any of the provisions under 127, 1 to 4 do not apply to the facts of the case. All the provisions under 127 refers to a scenario where an order is already passed. And in this case, no order has been passed, and it is pending adjudication. That application which is filed itself is not maintainable, and the court below had rightly dismissed the petition. Next, having heard the counsels on either side, there is the material on record. Now, the present application came to be filed under section 127. Before going into the same, it is appropriate to look at section 127, extract 127, the whole provision. So, as rightly pointed out with the learned counsel for the respondent, the entire provision of 127 deals about an order that is already passed under section 125, and thereafter any changes that has to be made by the court. In this case, that situation has not come. And then coming to whether a wife is entitled to maintain 2 applications for, can she receive double maintenance, or what is the other legalities of maintaining such an application, that can only be decided by the court on the merits of it. Those things cannot be agitated under section 127. When the application that is filed itself is not maintainable, now question of going into all these aspects which are on the merits of the matter would not arise. In that view of the matter, this writ petition is dismissed.
Because you have taken an order and I cannot question you.
So what liberty you want?
The liberty to appropriate remedy.
If the petitioner, it is needless to mention that if the petitioner has any other appropriate remedy, he is at liberty to pursue the same. Yes, next. 20? No, they will again check all the numbers. Yes.
Grateful.
2:30, call that matter. Yes, what has happened?
Mahesh Arupin 2:30
No matter
matter.
only. Have you served on him that copy?
I think they are not ready for a settlement.
They're not ready.
They are not ready. I am ready to give 50% and let him give 50%. That's what I suggested, my lord.
And shall pass orders on the merits? Heard reserved.
Merits, when, my lords? It may not take more than 10 minutes. Merits will not take than 10 minutes, my lord.
No, I said heard,
Matter is
you
reserved.
people have argued already.
Yes.
I said heard reserved.
Reserved.
It's only because neither of you are going to be benefited out of it. Court wanted you to have
Yes.
a time to shake your hands, but both your clients are not ready. Then we'll pass orders on merits. His client is not understanding what he can do. Yes.
For football hearings. Till number 9. Vijay Kumar Bhatt for petitioner. Shiva Kumar.
But as part of I make small submission, I make a small submission in this.
What are you saying?
What?
I make small submission,
You're for the respondent or the petitioner?
Respondent number 5 and 11. I am for the respondent 5 and 11. Yes, madam. I am for respondent number 5 and 11 only. Respondent number 19 already and respondent 19. Respondent number 9.
To how many respondents you are appearing?
No, respondent here, respondent number 19. Sorry, madam.
It's okay. You appear for whom? Now let us look at the cost title. Please come to the cost title. You have the papers?
Yes, madam.
Look at the papers. Page number 3.
Yes, madam.
To who you appear for everybody? All the respondents?
No, madam. Only respondent.
Appear.
Respondent 5 and 11, madam.
5 and 11 you appear. Yes. 5 and 11 you appear. Where is the 11th respondent? There is something, there is no 11 appears to be, 11, yes.
11 above, madam.
What about other respondents? Not at order. No, it is that advocate is not appearing for all the respondents.
No, madam.
Then the others are not represented,
No, madam.
unrepresented. Now let us look at this order. Order under revision.
Five.
75. What is the suit for?
For redemption of mark.
Redemption of mortgage. You are the plaintiff. What is this IA?
There is 500%. Of the not the land of that.
Hmm.
Staying the proceedings in the disposal of the tenancy application pending before the.
This application is filed. Is application is allowed.
Proceedings are stayed.
Now there is an interim order in this. There is an interim order in this. No interim order. The post is smart, registry verification notice to the parties. Yes. So and so, for respondents, already you have filed wakalat. Yes. Already respondent 5 and 12 are served for the remaining respondent. Yes, next.
Till number 10.
For the petitioner in this matter.
Yes.
Orders dated 13/6/20 to maintenance order passed by the domestic violence court. has changed in circumstances pursuant to that issued order. Was that the?
Where is the respondent?
My lord, she's part
My lords, I'm the respondent who's appearing through video conference.
Where is
my
the
lord.
issued order?
in order that they 84, my lord. But 898, my lord. 898.
Yes.
The operative portion, my lord, the reason signed is at page 108. In favor of the petitioner, while maintaining.
In view of the principle laid down in the above cited judgments, the respondent is directed to pay 15,000 per month to the petitioners as interim maintenance, including food, clothing, medical expenses, other monthly expenses. Clear arrears of maintenance within 3 months. Yes, why is this order bad?
My lord, if I may just pass on two decisions, my lord, of between the same parties, where the divorce proceeding stands allowed and permanent alimony of rupees 25 lakhs is awarded. And the court has held that the court has analyzed what all proceedings were initiated against him which were bad in law, including for section 377 of the IPC, whereas the marriage was not even consummated.
No, permanent alimony is also,
Please, my lord,
how
for
much is given?
25 lakhs permanent alimony is awarded. And during the pendency of the family court proceedings, also 20,000 per month was being paid. Till date, 18 lakh 2,000 is.
No, by the date this order is passed, already permanent alimony is granted.
Pursuant to this order, permanent alimony was.
So as on the day the order is passed, there is no permanent alimony.
Family court was 20,000 was being paid. Now, my lord, when this order came to be passed, we were not heard in the matter. Due to oversight, due to lapse on the part of the council on record, the matter was missed and this order came to be passed. And that is also forthcoming in the order. Further, my lord, reasons assigned are all in favor of the petitioner husband. The court says that payslips are not produced and she is employed and she is earning her salary and Rajni's reverses Neha as per that she is not entitled. However, in view of the judgment, I proceed to direct 15,000 to be paid as what is adjudicated. Now, the domestic violence proceedings are in the stage of respondent cross-examination, which is this husband has to be cross-examined. Such being the case, my lord, now here 15,000 per month is awarded from the date of petition.
Generally, that's how it is.
From 2014 and he has not been heard in the matter. Though, my lord, initially.
No, as you said, not hearing you is not the court's problem. You have not appeared.
Please, my lord.
So that is not the ground, number one. And now you can't take advantage of it now because permanent alimony is already granted, so she is not entitled. So we have to see we have to say it from 14 to till now. If she, once this permanent alimony is granted, later that is a different story. But you have to pay the arrears from there to here.
My lord, the portion of the arrears are already paid. In fact, because the execution was initiated, it is 3 lakhs was paid about 15 days ago. And as on date, my lord, 28 lakhs, my lord, in that 10 lakhs is deposited before this honorable court in MFA proceedings where permanent alimony is under challenge. She has not challenged that order where the decree of divorce is granted.
So, because those proceedings are stalled, those proceedings and whatever the permanent alimony, no, she will not get only 10 lakhs, your deposit. Please understand, all these figures, the court is not concerned.
One more factor I would lost sight of my lord is that she's an educated individual. She's earning, she's employed.
How much you're earning?
Graduate.
How much you're earning? How much you're earning? How much the husband is earning?
My husband is earning 1,50,000.
How much the wife is earning?
She is earning about 40,000 per month. Such being the case, my lord, and the trial court has arrived at the finding that the marriage was only for 23 days. And marriage lasted for 23 days in 2013. Marriage was not consummated. Parties have not resided beyond 23 days. And she has.
All those issues are not the concern of the court while deciding this application.
My lord, at least in view of change of
And
circumstances, I may be permitted to agitate my cause there. And the trial could be directly hear me before and reconsider this order also, my lord. Because now it's in the back end of respondent evidence and all this material is placed before the trial court in evidence.
When is this order passed by the court?
13/6/2023.
Hmm.
Subsequently,
The petition is filed in the year 2015. 2015, 2014.
Divorce proceedings initiated in 2014 itself.
No, not the divorce proceedings, it's criminal. This order, 2014. When she sought for an interim maintenance, 2014, court grants it 2023.
My lord,
So again, now this order has to be set aside and this has to be remanded to the court. Why?
My lord, since we are at the far end of the trial, then anyway.
That is very unfortunate that the court kept this matter pending till 2023.
There was another proceeding before this honorable court itself in GMS. What happened was the respondent had suppressed the existence of the maintenance awarded in the divorce proceedings, and she had obtained a maintenance order in the domestic violence proceedings also.
No,
In the line that
domestic violence, whatever the order that will be passed by the court, that is independent of any other proceedings. Just because she has a maintenance under the domestic violence, it will not preclude her from claiming maintenance under the other statutes.
Please, my lord, she will not be precluded. However, she has to apprise the court of the maintenance which has been granted in other.
No, we are not on all that points. Now, as far as this order is concerned, why it has to be interfered?
Page 108 and page 109. If I may read this at page
Yes.
109. Page 108. Generally,
Yes.
the court at para 14 allowed the last but fifth line.
Yes.
Generally, the court has to take care of the status which she was enjoying in shared household. But in the instant case, the parties to the petition have not led matrimonial life for a longer period, and even if both sides' contention is taken into consideration, period of matrimonial life led by the parties will not exceed 45 days. The court cannot consider the status of the parties in the instant case because the petitioner, though contended she was forced to resign from the job and hence she is in distress. The petitioner, either in her petition or in her affidavit, has not stated the details of the job, what is the position, salary drawn. Petitioner further contended about loans borrowed, but no document is placed before the court. This court, as well as family court, awarded interim maintenance, and if she borrowed loans for his lavish lifestyle, respondent is not bound to repay the same. Court cannot hold liable for the same unless established it is for the need of basic amenities. Petitioner has not furnished parent job offer, a salary slip and nature of work. Petitioner, upon perusal of education qualification, appears to be a well-qualified woman residing in Bangalore, and with regard to rent, no document is placed before the court. And at this stage, the court is deciding the interim maintenance and not permanent maintenance. As discussed earlier, interim maintenance awarded with certain object, so that petitioner should not suffer severe hardship with the effect of her.
Now, before the family court, from when you are paying 20,000?
From the date of the application, 2018.
2018. So from 2018, you are paying 20,000. In this petition, how much she sought?
This petition also she sought for maintenance of 50,000.
In the family court,
In the family court, around 20,000 was awarded.
how much she sought? So you're paying 20,000 from 2018.
Hello, she sought about 50,000. The family court as well. Hello, the family court documents are not forthcoming.
Yes.
However, 20,000 was awarded in the family court and it's being paid since 2018. This sort of entire reasoning, my lord, indicates that
What is your salary?
My lords, I'm getting 30, 31 sometimes, earlier 23,000. And my husband's salary is more than 4 lakhs per month. He is engineering passed out 98 student, 98 in the year he completed. Post that he is continuing his job till 4 years, nearly 25 years. And he is not revealing his salary anywhere, no pay slip, nothing. He is getting more than 4 lakhs per month salary, my lords. And coming to that family court maintenance, 20,000 rupees has been awarded, my lords. But 20,000 till now, the arrears are more than 13 lakhs or something. But they have paid till today 70,000 rupees. There I sought it for 1 lakh per month. 20,000 rupees has been ordered. There they are not paying. And coming to this DV court order, it is 2014 I have filed application seeking for the interim maintenance. And as I agreed, it's a 23 days of marriage because my marriage is completely cheating marriage. He just married me and he flew to UK. And after that, he has done all these natak. And 2014 to 2019 March, the matter was stayed by Honorable High Court. And later 2019, till 2019, single rupee I have not been awarded in the DV matter. 2014 to 2019 March, DV matter was stayed completely. In the month of March 2019, Honorable High Court clearly said it's a clear-cut case of domestic violence where we don't want to interfere into this matter. The matter will be remanded back. Will you take back the matter or shall the Honorable High Court involve and dismiss your petition? Then these people said, no, don't dismiss our petition. We will only withdraw the matter. Then clearly court has said both of you can go to lower court and contest the matter. And clearly Honorable High Court told me, yes, we agreed that your case is a genuine case. You go and tell entire story to the lower court. Then both parties were directed to appear before the lower court, magistrate court. It's a kind of intimation to those people, the petitioner. They have not come and they have not appeared before the DV court. Court has again reopened the case, lower court, and sent the summons to these people 2 times. That also they have not. These people only came to High Court and matter was stayed 5 years. Honorable High Court clearly said them, I can produce all the orders, all the documents when I'll be filing the objections. And after that, they have not. I myself took the permission from the lower court and took the hand summon, and I have served to the counsel of the my husband. In the High Court premises only I have given, and he has endorsed with the signature. He said, okay, we will come. That time also they have not come and they have not appeared. It is happened 2019 when matter was remanded. 2019 again they have not came before the lower court. Court said, you tell ma, you appear, anyways you are appearing, you tell about your problem, court will hear the matter. Court heard it, and very nominal 20,000 rupees. At the time his salary was more than 3 lakhs rupees, but court has nominal way only 20,000 rupees granted. That order they have not challenged before magistrate. They have come and they have challenged it in the year 2020 January before again High Court of Karnataka. Then the court said 20,000 rupees, arrears is 12 lakhs rupees something. So half you can, 50% you can pay, remaining 50% Honorable High Court will hear. And don't stop that 20,000, she will be in a trouble. 20,000 in the DV case, they were paying the maintenance. Nowhere they have paid any amount in the family court. Family court order, they were not obliging. 20,000 as per the High Court order, then half of the arrears they paid. Remaining half, 2022 November, it has again come before Honorable High Court. Then these people said it's a violation of principles of natural justice. We have not been heard. We have not given any chance. The order was passed one-sided only. On 5 years, the matter was lying in High Court. Honorable High Court only told you to go and contest the matter. You are not appearing.
Yes. What happened thereafter? What happened?
Then the Honorable High Court said, okay, fine. Anyways, violation of principles of natural justice, this, that, and all you are telling. We are remanding the matter to lower court. Again, remanded back the matter to DV court. DV court 2022 November. And they said clearly that don't stop that 20,000 in the family court, because one maintenance at least she should get. Otherwise, she cannot survive. That also single rupee they have not paid. 2022 to till 3-4 months back, they have not paid a single rupee. That order, they were just taken advantage, and they, after remanded back the matter also, they have not appeared. And they were appearing starting, and now she is contending that no, we have not appeared. My lawyer has not there. The junior lawyer left the job, and all these things.
Anything else? How many times this DVC would come to High Court and how many times it would be remanded?
I set out the reasoning of the trial court versus honorable court. The entire reasoning.
But that you have argued. I'll record it. Now, what is happening? How many times this we are not able to appear? Principles of natural justice, as she's putting. How many times you will come to the High Court? How many times you will go back?
Once when the.
So now this is also second time.
The page 199.
One?
The order which she is talking about, 199, page 199. Where, my lord, in these proceedings, because she suppressed the fact that domestic maintenance was awarded in the family court, she obtained orders in the domestic violence court saying she has children. Hence, we challenged it, my lord. And both the orders of the family court and the domestic violence court was taken into consideration.
What is the order?
Page 199.
What it says?
In view of the particular circumstances, the wife has already paid the above maintenance fees under the Protection of Women from Domestic Violence Act or under the MC proceedings. The amount paid under the Domestic Violence Act, this is at page 199.
Yes.
The amount shall be set off. Amount paid under the Domestic Violence Act shall be set off against the amount to be paid under the proceedings in MC proceedings, as there cannot be dual payment in the matter in light of 20,000 being awarded. Further, at paragraph 4 at page 198, the court says order passed by the court under section 23(2) of the DV Act is set aside and matter remanded back to the hands of the concerned court to hear the parties of the application and pass appropriate orders in accordance with law. Here, my lord, the order of the family court was upheld and the order of the domestic violence was remanded back. Why, my lord? That is at page 46. The lordship may kindly favors page 46.
Why maintenance? No, maintenance under DVC and maintenance under 24 are not maintainable.
Last para says that it's primarily saying that it has to be apportioned. Whatever is paid under the DV matter, it has to be apportioned towards maintenance payable under the family court proceedings. And DV is remanded back is what the order said. Now, at page 46 of your lordship, may kindly peruse the impute order and those proceedings. At page 46, the application is supported with a separate affidavit sworn by the petitioner, wherein she says that respondent number 1 not taking care of herself and her children and is not paying any maintenance to her. My lord, their whole case is that the marriage was not consummated. It was only 23 days of marriage, and on the same day of hearing, the matter was posted for orders. And in view of that, it was under challenge at that point in time, and it was remanded. Such being the case, my lord, now at this stage, on 13/6/23, this order comes to be passed, directing the husband to pay ₹15,000 from the date of the petition. Now, my lord, the entire reasoning assigned here indicates that she should not be entitled for any further maintenance. However, the court at the part end indicates that 15,000 may be directly paid. Hence, since all facts are not taken into consideration, and in view of the further facts and circumstances which have arisen between the parties, my lord, with respect to the divorce proceedings having culminated, where there is a finding tendered by the trial court, lordship may kindly peruse the memo which I will file along with the judgment. Third, my lord, the trial court has tendered a finding that the petitioner has suffered untold hardship and torture at the hands of the at page 15. And further, without assigning any reason, 25 lakhs is however awarded permanent alimony. This, my lord, is at page. I just filed a memo.
How are they relevant for considering this petition?
My lords, can I be permitted to say something about the family court order, my lords? It was passed one-sided, my lords, which I am going to challenge it before Honorable High Court. Last time, Honorable High Court has given me the chance to file an appeal also. This my cross examination has not been done, my evidence has not been taken anything. My mother, she is suffering in Orissa, so I went there for 20 days. In the meanwhile, these people have submitted what and all false submission before the family court, and it was passed one-sided order. It's an ex parte order, which I have already submitted before the Honorable High Court, which I'm going to challenge it, my lords. In the meanwhile, I'm facing with the dengue fever. I was hospitalized. So this order is completely absence of me. I have not taken a single rupee from the family court order. Because my husband per month income only 4 lakhs rupees, crores of rupees he has earned, and he cheated me and he left me like an orphan. So how come this order? My submission has not been taken on record by the family court. And clearly Honorable High Court said, you file appeal, ma, this petition we will dismiss it, MFA, which they have challenged it. And 10 lakhs rupees which they have deposited in the Honorable High Court account, I have not taken a single rupee. Because my absence, that order has been passed. It's a one-sided. My cross has not been done. My evidence has not been taken on record. Nothing. And he has not filed any assets and liabilities also. On what basis family court has passed such kind of order? Because these people are influencing. They are making all false
Please don't
submissions.
make all those submissions.
No,
Please
my lords, this is my pain. I'm telling out of my
Not
pain.
necessary. Please tell them what is relevant, not all that.
My lords, I was not there. Family court, one-sided order
Yes,
has been
an
completed.
ex parte order is passed that you are questioned. Then that is
Yes, my lord.
sufficient.
Yes, I have submitted the same thing to
Yes.
Honorable High Court also. They asked me to file an appeal. They asked me to file an appeal for
Then
challenging
file an
the order.
appeal.
I'm filing,
File an
my lords,
appeal.
because 2 days back only I have discharged from
Yes,
dengue
yes.
fever. I'll be filing, my lord.
Yes, file.
And family court, if at all they have paid any monthly maintenance 20,000 rupees regularly, which they are telling, let them put the proof before Honorable High Court that where in which account to whom they have paid. They are not paying anything in the family court. This 15,000 also, 2022 to till now it was stopped. That again they
No,
have started
when
paying.
is the divorce decree granted?
Dated
November 2020.
November?
28, 2023.
Yes, please come. The agreed with the orders passed in. I number 1 in criminal miscellaneous number 150 of 2014 dated 13/6/2023. The husband is before this court. Parties are referred to as wife and husband. The wife, in view of the disputes between the parties, the husband had filed MC number,
1347 of 40.
her husband has filed MC
1347.
1347 of 2014 seeking divorce. Wife had filed a complaint under the Domestic Violence Act. And also she filed a petition for interim order of maintenance at rupees 50,000 per to her in the year 2014.
Application was filed on 2018.
Is it not in the family court? I'm saying about this petition. Is filed in the year 2014. Earlier, when an order is passed, WP number 59585 of 2014 was filed against which order?
That they have challenged for quashing of the proceedings, my lords.
Where they sought for quashing of
They had the stay was there till 2019.
that was subsequently withdrawn.
When?
Court has given. March 2019, court clearly said, will you take back the matter or court shall involve and dismiss your petition?
They filed the proceedings. They have sought to quash the proceedings in the domestic violence case. and they have filed the WP number 59585 of 2014. Initially there was a stay.
Initially, I was not there. These people have taken
Initially,
stay.
there was a stay, and later the same was withdrawn when?
The March 2019, my lord, date
In the month of
exactly.
March 2019, the same was withdrawn. Thereafter,
Court clearly said it's a classic case of domestic violence. It cannot be quashed by a honorable high court. Will you take back, or shall the court will involve and dismiss your petition? Then they said, we will withdraw it. Don't dismiss the
then
petition.
the court
This is what
had,
happened.
and later, after the said writ petition was withdrawn, then the court had granted maintenance of an amount of rupees 20,000 per month. Then agreed thereby their preferred criminal appeal number 2040 of 2019. And the appeal came to be dismissed on 10/12/2019. Then agreed thereby.
That appeal was not dismissed.
Dismissed.
No, thereafter you further it.
Because the interim order of refuge.
My lords, in that Sessions Court clearly said we cannot give the stay for the proceedings. Order is proper only.
Interim order on in criminal appeal number 2040 of
Not
2019.
granted stay.
When there was no interim order was granted. That is what recorded by the court in the order. That's what I am recording. On 10/2/20, they have filed a writ petition before this court. Thereafter, again, the matter was remanded back to the court below. And after the remand, and when the matter was pending before the court had clubbed WP number 3417 of 2020 and WP number 15154 of 2019. And the evidence was let in thereafter. Before the court, the evidence was let in by the parties. It is a case of the husband that the wife had maintenance in a matrimonial case under section 24. There was maintenance of 20,000, and when the decree of divorce was granted, permanent alimony of an amount of rupees 25 lakhs was granted. It is a case of the petitioner husband that the court having given several findings stating that the wife has not filed all the documents about her earning capacity, and as per the judgment of the Honorable Apex Court in Rashesh versus Neha, though all the documents are not placed.
No,
before the court.
sorry to interrupt, my lord. My lord, I have filed.
Our contention.
Okay, sorry.
What did you write? So and so were not filed, and court having given several findings with regard to against, as if all the findings are against the wife. But when it comes to the maintenance, court had granted 15,000 as maintenance. For 15,000 as maintenance from the date of petition that relates back to 2014. Land Council submits that they hardly lived together for 20 days, 23 days, and 23 days. Now the whole litigation is going on between the parties from 2014. It is submitted that the wife is not entitled for any maintenance. The findings of the court makes it very clear. It is submitted that when already permanent alimony is granted, now the question of paying the maintenance would not arise further. It is submitted that further it is submitted that while this order is passed, they couldn't in view of for various reasons, the husband could not represent his case, as there was no and this order is passed without hearing the husband. As such, if this order is set aside and the matter is remanded back to the court below, they'll be able to, after hearing the husband, the court can pass appropriate orders. And at any cost, the order impugned before this court is unsustainable and the same is liable to be dismissed. Next for land counsel appearing for the party in person who appeared through EC submits that right from 2014 till now, this matter is going on. And several times it has come up before this court. And the matter was pending as in view of the stay orders granted by the court. And when she sought for maintenance in 2014, till this impugned order, on one pretext or the other, the matter has been adjourned, the orders are set aside, the matters are remanded. It is stated that in spite of notices issued to the husband, conveniently, they are not appearing before the court. And now at this point of time, the counsel for the petitioner cannot make a submission that the matter has to be remanded back. It is submitted by the party in person that though under the Family Courts Act, under section 24 of the Act, an amount of rupees 20,000 is granted. That was never paid to the wife. It is stated that even in this case, earlier by order of the court, when 20,000 is directed to be paid, even in that amount also there are arrears running into lakhs of rupees. It is submitted that she in the MFA, that is MFA, she has not questioned the decree of divorce, and the husband has questioned it in that there was a direction to pay an amount of rupees 10,000.
10 lakhs.
10 lakhs. It is further submitted that but in 2014, when she was driven out of the house, and at that point of time, when an interim application is filed seeking maintenance for the best reasons known to the husband, that the matter has been litigated over a period of 10 years, and still she could not till now she could not till now even the amounts are not paid. And the order that is passed with the court is a well-considered one. Next para. Having heard the counsels on either side, there is a material on record. The court, when an application is, when she has filed a domestic violence case in the year 2014, the case or the interim application is for the immediate necessities. Unfortunately, in all these matrimonial proceedings, though sometimes those interim applications are disposed of along with the final application. The purpose and the purport for which such provision is incorporated either under the Hindu Marriage Act or under the Domestic Violence Act, that is itself defeated. The courts have to pass appropriate orders at least a maximum within a period of 2 or 3 months from the date of appearance, accommodating the parties. But unfortunately, now in a application of 2014, this order impugned is passed on 13/6/2023. By that time, a decree of divorce is also granted. That is on.
No, my lord. By that time, it was not passed.
When was the
anyway.
decree of divorce granted?
November 2023, recently.
November 28, 2023.
November 28, 2023. And immediately after 5 months from that day, the order is passed where the court has fixed the permanent alimony. Now, the order that is passed with the court granting 20,000 maintenance has culminated into the final order that is passed in the matrimonial case. Now, coming to this case, the learned counsel submits that the court has given various reasons that the wife had not filed her statement of assets and liabilities, and she is not entitled for maintenance, and several other grounds are stated. Now, in this case, there is even according to the petitioner is a husband. Her husband is earning 1,25,000. According to the respondent wife, he is earning 4 lakhs and odd. Now, without even taking the admitted amount as stated by the husband, 1,25,000, and the wife is earning 30,000 and odd. 1,50,000, and the wife is earning 30,000. And in that case, the court has granted 20,000 under the section 24 of the Hindu Marriage Act. It is a case of the wife that it is not paid. So when it comes to the relief that is sought under the Domestic Violence Act is concerned, it is an independent remedy and relief to the party. And just because the maintenance is granted under the Domestic Violence Act, that will not preclude the party from claiming further maintenance in other proceedings. Then now admittedly in the matrimonial proceedings, a petition under section 24 of the Act is filed in the year 2018. You said so. 2018. That's what I'm saying. Then in the MC case, interim application for maintenance is filed in the year 2019. Right from 2014, under any of the acts, she was not receiving, was not getting any amount. Now the divorce is granted on 28/11 November 2023. 28/11/2023. According to the learned counsel for the petitioner in the domestic violence case, not in the domestic violence case. Are you accepting that? 4,37,000 in domestic violence case?
Per month, as per the 15,000 rupees order, whatever the arrears are there, that they paid 15,000 rupees order.
4,37,000.
Not family court one. Family court one, they have not.
37,000 they have paid. And how much are the arrears now? Still?
There is no arrears. Arrears are not there. Recently, they have started paying from 2022 order. They again stopped it for nearly 2 years. Recently, they cleared that arrears.
However, my lords, in the repetition order, whatever we had paid was set off against the family court maintenance order. So as on date, in the domestic violence, arrears are 13 lakhs.
Whatever it is, that according to
Stands paid under the family court.
yes, it is submitted that the what do you write? $37,000. Not 37. She like 4 lakh. 4 lakh.
My lords, that is not 4 lakhs, my lords. 3 lakh odd something. She is falsely submitting that one.
Take out that. It is stated that some of the amount is already paid.
Arrears they cleared that.
And some more amounts need to be paid. The husband, when he is earning and is and admittedly is earning 3-4 times than the wife. And when with that money, what she is earning, if she is not in a position to maintain herself, the purport of section 24 and the section 20 of the 12 of Domestic Violence Act is for the same. But unfortunate state of affairs in this case, where a petition that is filed in 2014, an order for a final order to be passed, it took till 2023 in view of various litigation filed by the husband before the courts. Ultimately, the fact remains is the wife could not get any amount from the in these petitions, considering the fact that on 28/11/2023, that the divorce is already granted and
One-sided,
the same is standing before the court. The husband, the order of the court below is confirmed, and he shall continue to pay. He shall pay the arrears. He shall pay the amount at rupees 15,000 till 28/11/2023. And 23, coming to the submission that the matter has to be remanded by giving an opportunity, that submission has no legs to stand, and this court cannot consider for the reason that this, on these grounds, several times the matters are being remanded. And first, an application 2014 on these grounds is now, finally an order is passed in 2023, and this court finds no reasons to remand the matter. Accordingly, disposed of.
With regard to that, probation that no amount is paid under the act.
That's her contention.
Paid under the DB said. So it said that it was pending since 2013 and no amount was paid, that would not be correct.
Yes, I'll look into it. Yes.
Cell number 11, KG comments for petitioner.
What do you want? Where is that? Then counsel for the petitioner submits that as per the direction of this court. He has served the notice on the counsel appearing before the court below and filed a memo to that effect. What is the name? It shows that the counsel, Mr. K.A. Patil, has received the notice. Print the name of Mr. K.A. Patil. Post this, and the registry is directed to print the name of Mr. K.A. Patil. Post this matter on Thursday. Thursday. Yes, next. Thursday. No. In this visitation rights and these kind of things, no ex parte order. That is true. That's what I'm saying. In all these matters, without the parents will not pass any order. Huh? No, that is true. Provided there is appearance. That's why I asked you to take out notice. Yes, next.
Cell number 12,
Yes.
Bishop. Immediately for petitioner.
Why? Post this matter on 23rd at the request of front counsel for the petitioner. Yes.
Cell number 13,
Hmm.
Very strange case, because the petitioner and respondent
What is the impugned order? Then you can tell the,
came 70.
yes.
If they have to pay 70 law. The honorable could have passed the order.
The petition is maintainable. Issue arrest warrant against the respondent.
Is the, without hearing issue, the proper hearing at court process order, whatever. The respondent is not the way from the petitioner, there is no any measure at all. There is a suit filed by the petitioner.
No. Now when order is passed, for so and so amount is granted. Have you questioned the said order? In criminal miscellaneous number so and so, an order is passed on 5/2/2024. When is the order of the date? 17/7/2014. What has happened to that order?
This is actual date. It is not actual rule. Next year, this is the order. Earlier order. Next year,
Have you questioned that order?
date number 25.
20?
25, date 25.
Uh,
Next week. Condition not. The claim amount is 2,88,000, 25 days and 25. As for the petition, on petition of petition, the petitioner responded to 20,000 and 5,000. Amount was directly deposited by the petitioner's account on 26/7/17 and 12/10/17 of 70% fees and 20% fees amount were deposited before the Honorable Karnataka. Considering the payment made by the respondent in the present case, is excess. Therefore, it just and proper to close the case as full satisfied. After this went on, he first the question down. And the D was filed. After closing this petition, he filed another petition. And the D will be. This is T, page number 45. On this, the court passes the order like that.
What is this?
Another petition, 181. The first petition.
Arrears of maintenance from 6/9/2014 to 5/2/2024.
When this one page number 47, in page B. The claiming what amount belong 6/9/2014 was paid long back.
Then why did you not appear before the court and tell the court all this?
One claim belongs to the respondent court.
Please come to the order. Come to the impugned order. Page number,
Page number 17 belong.
yes.
The fourth paragraph. Fourth
Ah.
paragraph. Page number 17, fourth paragraph. Page number 17.
Please read.
Today, don't advocate correspondent a find. Remove along with the suggestions to report taking areas to receipt 240 in the case of Tony versus to Manish Kumar Chinchal. In my opinion, since the facts of the case on hand are not similar. Shared suggestions are.
No, you say that, you file a judgment and say that that lady is not your wife. Can you raise those grounds in execution?
Oh, mind, it is the point here. Is the point belong?
Then why did you pay earlier? You paid earlier. You paid the amount earlier. So for half of the amount you can pay.
Because of the will advice of the earlier question, that is the advice.
Then we will see take out notice. Petition is permitted to take out notice on the counsel appearing before the court below. No.
It's a government employee law and government employee. Arrest for a district. It is because otherwise.
But because on the face of it, you can't convince the court what is the reason for that. Why did you, it is not about wrong advice, ill advice. When an order is passed granting maintenance, unless and until you question that order, you cannot say any other thing at a later point of time. That's why I asked you, in the year 2014, when an order is passed, have you questioned it? You have not questioned it. It has become final. Not now. You have to question it by filing an appropriate petition. What has happened? Then what to do? It is closed. So how can it be closed when your contention itself is that she is not the wife and you are not liable to pay the
Obeying the orders of the court law, to honor the orders of the court, to pay the amount of law, and make this my discriminatory.
Now, please tell the court where this issue can be decided. This issue can be decided in the appeal filed against that order. That appeal is closed according to you, that RPFC, for various reasons which the court do not know. Then in that case, how can you agitate all these issues in a EP? You cannot, because you are a party. You are a party to the original order, which is not set aside by any appellate court. When it is attained finality, now in a EP proceedings, all these questions can't be considered. Show, please tell the court about what has happened to the order of 2014. Nothing else is concerned as far as the EP is concerned. You're not understanding. By saying that you're on a more losing this thing. You're not now when you say that they have already paid, that means you have honored the order passed by the court.
Subject to the OS law, right? OS law.
What has happened to the OS? And then till it is decided, then you can think. But as long as it is decided, you have to pay. Unfortunately, all these things can't be considered. Can't be considered. An order which has been passed in 2014, which has attained finality, whatever grounds you want to agitate now in the execution proceedings are not permissible. To grant stay of the order, you have to prima facie convince the court what are the reasons. This court is not convinced because that is not legally permissible. I'll post it tomorrow. If you want to take a call, take. or else on Thursday, or else we have to, in fact, it's a case to be dismissed on the face of it. But still court is giving you an opportunity to take a notice because nothing can be done. Ultimately, it has to go. No, what are the reasons to be adjudicated? Tell the court. You tell the one reason that what is to be adjudicated in this petition. Now, this court cannot say that the order passed in criminal miscellaneous of 2014 is wrong because this is not where the court is sitting. Now you are invoking the jurisdiction of this court, questioning that particular order, that whereas the warrant issued against you. Is it not? So when the main order attained finality, considering whether she is wife or not before the trial court, before the executing court will not arise. And you have to pay the money as long as that order is there. I understand, but that is not the scope of this writ petition. That court cannot go into it. That what I'm saying is this has to be dismissed straight away. But I'm giving you an opportunity, take notice, but I'll not stay this. Petition is permitted to take out notice to the respondent, counsel appearing before the court below, pose this matter on 5th of August. Yes. No, this court is not a forum where you can come and just like that take. Now, unless and until a writ petition can't be entertained, why should there be an interim order? Yes, you will receive a warrant if you not pay the amount. That is not your contention before the court. If you said so, you have paid excess, that is a different issue. You say that she is not my wife, so I am not reliable to pay the maintenance is your stand. Now, how can that be decided? If you say, I have paid the amount, in spite of that, the proceedings or execution proceedings are initiated, then the court will come to your rescue. That's not your stand. Your stand is you are not the wife, she is not the wife. No. Yes, post is smarter on August 5th. Yes.
Cell number
next.
parted matter, cell number 14, Vinayaka B. Petitioner.
Huh? At the request of learned counsel, the petitioner post this matter on the caption part heard. Post this matter on Tuesday, 23rd, same under the part heard.
Cell number 15,
For respondent, 1 week time,
Nothing.
senior out of station. Next week, I'll
Give the file. On 12/6/2024, as there is no representation on behalf of both the parties, the matter was directed to be listed for dismissal. On on 8/7/2024, at the request of learned counsel, the petitioner, the matter was directed to be directed this matter to be posted on the caption part heard. There is no representation on behalf of the petitioner. Post for dismissal on 22nd. Yes.
cell number 16,
Ladyship, I appear for the respondent of this case.
Yes, short passover. Just call the next matter.
cell number
17.
17. 17,
Yes,
Prakash Reddy,
yes.
Prakash Reddy.
Yes. Yes. Unfortunately, it was, matter was heard, matter was argued, heard, and basing on that, the order is passed in the presence of the advocates. It has to be, I will not read each and every ground. No. And the grounds are to be agitated by the councils who are appearing before the court. Is it not? I will not be reading what has been written in the grounds. Whatever is argued and from what the court hears and what the court will pass order. And yes. Hmm. Yes. Yes.
Para 111. Page 371. Para 77.
1 minute, let me just look at the order. What has been? Yes, let us look at the petition filed for review. Yes. Where are the grounds? I think all these grounds are grounds for filing an appeal. All these grounds that are all these grounds that are raised are grounds for filing an appeal than a review. No. What is the scope of a review and what are all these grounds? If the court has not considered the law, then it's a ground for whatever, if there is an error apparent on the face of the order. You are saying that these are all the contentions. Court is not considered, file an appeal against this. It can be passed. No, what is the scope of a review? But that I fail to consider, assuming that I fail to consider a law. Law, law, it is not that.
She is a lawyer, but she is not a great person. She is a junior lawyer, lawyer to the color and how they are, you can so much you get this payment from the seniors. Here only she is not having a court is between this.
Yes.
Then you are watching, you see, child is studying in school and he gives,
Yes.
this board has done only 5%. And I checked with the earlier content 10,000 rupees. 10,000 rupees is not something in the Bangalore to even pay the school fee. That was not filtered in the score.
Yes.
What if they see the judgment or not?
Yes. Please give the judgment. Rajneesh Sneha.
For there.
Yes.
Para 77. Page 371.
Yes. Yes. Yes.
The object of granting interim or permanent agreement is to do that the dependent spouse is not used to distribution or preferential amount of the value of the marriage.
Yes.
And not as a condition of the other spouse. There is no straight jacket formula for fixing the quantum of payments to be enforced.
Yes.
Both inter or the status of the parties, reasonable needs of the wife and dependent children, that the applicant is educated and professionally qualified, whether the applicant has any independent source of income, whether the income is sufficient to enable her to maintain the same standard of living as she was accustomed to do in her metropolitan home, whether the applicant was employed prior to her marriage, whether she was working during the subsistence of the marriage, whether the wife was required to sacrifice her employment opportunities for nurturing the child, training, and bringing of the adult members of the family, reasonable cost of mitigating burden on the children.
Yes.
In this case, also, what you see when she was in New Zealand. At that time, there was she was in agreement. When she came to the India, both are going to the India. Here she is not employed, and even your lordship will see even during the day, New Zealand, she was pregnant, second day. After she came to the India, then she gave birth to a child. Now we will manage the 10 years. Now she is studying in the school and she has to pay. There is no income for her. That was not considered the store.
Yes.
And one more judgment.
Yes, please pass on.
Even in this case, we are not restored. Government will stop the store.
Yes.
That is in. Page number 2688 of 2020.
Yes. Yes.
There is also the sport considered indicted more by this year.
Yes. Yes. Yes.
The short vote is the subject and the not cannot mean that the woman will be constrained to be in your house. It's not allowed to be that she has fallen from the grace and move either arranging for system. The effects short vote that the quantum of maintenance should be for the life she was living with her husband. Then your wife will finally export in the water. Page 30.
Yes.
1,50,000. I am not, he is not working.
No, actually, there are two aspects to this. This court is very much interested to hear and consider the cases. Now, when the arguments are led and when whatever basing on their arguments, whatever is argued, court has considered and passed orders. Now, like, this is not the procedure where a review is filed. But still the court will consider, you argue, the court will consider. But this is not the procedure. Now, whatever that day, none of the judgments, nothing has been argued. Nothing has been argued of this nature, except saying that she is a so-and-so, she's entitled. Now, either for her to say, or either for the others to say, no, I don't file my assets of statement of assets and liabilities, but others have not filed. Please look at Rajneesh versus Neha, how it holds good. This is one point. Next, both of us have not filed. Both of us have not filed. Please remand the matter to the court below. Court, then it will be decided is another submission. No, when any of these submissions are not, and basing on what is on record, court passed an order. Now, if on these kind of orders, every time a review is filed, I think that is like abusing the, that jurisdiction of review. The parameters for review as a senior counsel, you're very much aware. But no, what has been placed before this court are not something for a review. It is more or less an appeal. More or less an appeal. Saying that your order is bad, then go to the appellate court and question it. But still we'll consider it. Yes. Next one. Reserve.
Cell number 18. 18, Chidambara GS for petitioner. SDN Prasad.
Yes. Defendant? Where is the counsel for the respondent in this case?
I appeal for the respondent.
No, not that. In the earlier case, Mr. Counsel.
That will not.
Ask him.
Yes. That Prakash Reddy, sir.
I think in this notice is not served on the respondent. The counsel who is appearing, you can take out notice on him. No, petitioner is, and you heard the formal petitioner for the petition is permitted to take out notice on the counsel appearing before, on the counsel earlier appeared in the writ petition and filed a proof of service. Post this matter on Monday. File a memo to that effect. Yes. You are the defendant in the suit. What is the suit for? Suit for?
Partition.
Partition. Suit is of which year? 2001. Too early. It is here. Court is hearing. Good. Yes. You are appearing for defendant? Counterclaim, some other properties are added. Is added. Which year is this? Anyhow, next. When?
31/7/2000, 6/8/2000.
6/8?
Came to be dismissed on 31/7/2013.
31/7/2013.
13.
That was came to be allowed on 13. Page number. No, anyhow, 7/12/2013. What is the impugned order now? And restored, subject to condition that the plaintiffs have to pay 5,000 rupees fast. And to appear before the parties have the right to appear before the court on 3. Let's see this order, 7/12/2013, page number. 69. Lord, by imposing cost of 200 on each application. What are these two applications? Delay is there.
Yes.
Then what happened?
Only after.
No, I'm not able to find what you're reading. 70. Which is defendant number 4. How it starts, the para? One. Yes. Yes.
Restored on only after payment of card. It must be paid.
District Legal Services.
On a state of hearing without fail. So directed the matter to be posted to. Case is not listed.
Subsequently, I have filed an application. Consider my property. It was pending. And by the intruder, I put a rejected me application.
There is a
Delay.
no. You said your counterclaim is long back ordered.
No, was made. That is pending consideration.
That was on 31/7. When is the date of your counterclaim? You said along with that you filed your. That is when, which year? So right from then, it was not considered. 13? 12? 303, 2000? Now let's see the order. No, what is happening to this year suit from 2001 to 2013 without even considering your counterclaim? Let us see. What is this? Suit for partition. What is this order?
The application, your lordship, I kindly see, suit came to be dismissed in 2013. An application for restoration, or rather to consider the application for counterclaim, was filed after a lapse of 2 years. 1 year, 8 months.
Counterclaim, he has already filed along with the.
He had, along with the written statement itself, he had made counterclaim. My suit came to be dismissed for non-prosecution. His contention is that irrespective of my suit being dismissed, his counterclaim should have been continued.
But anyhow, your case is already restored.
No, my case is not restored because I did not pay the cost. Suit is not restored.
No, suit is not restored.
Suit is not restored. Subject to the condition.
You didn't question it later or you didn't file any application?
No.
You are okay with it?
My clients did not pursue that.
Please come. I'm allowing the writ petition. Agreed with the order passed in. What is IA?
Number is not given.
Agreed by an order passed, I agreed by an order dated, at least order, date of the order is there?
It should have been accompanied by an application for condonation of delay. That was not done. That is the basis on which the application came to be rejected.
On dated 13/3/2015.
So it was filed after a lapse of 1 year, 8 months. That's the reason.
13.
It is given.
Agreed with order dated 13/3/2015. 15. The defendant number 2 to 9 or before this court. The respondent herein had filed a suit for partition. In that, huh? 2 to 7, that's what I said. The respondent herein had filed a suit seeking partition in separate portion of the suit scheduled properties. In that, the defendant number 2 to 7 have filed their written statement and also a counterclaim in respect of one of the plain scheduled property. As per the item 1 of the plain scheduled property, or originally item number 1 of the plain scheduled property. Then on 31/7/2013, the suit came to be dismissed for non-prosecution. The plaintiff had filed an application seeking the restoration of the same, which came to be restored on 7/12/2013 on a condition that he shall pay an amount of 5,000 as cost. As the plaintiff failed to pay the cost, the suit was not restored. Then the present application came to be filed, stating that a counterclaim of the defendant is there. As such, the same has to be decided by the court. In the court by order impugned had dismissed the same. While dismissing the same, the court has observed that the suit came to be dismissed for non-prosecution on 31/7/2013. And when the same was allowed on cost of 5,000, and when the defendant is claiming, has filed a counterclaim, and when the suit was dismissed, the suit was dismissed on 31/7/2013 for non-prosecution, it is the defendants are duty bound to bring it to the notice of the court about their counterclaim. He has not brought the same to the notice of the court. Even at the time of restoration application filed by the plaintiffs, even either on that day or on the day when the restoration application is filed, abruptly on 10/3/2015, the defendant number 5 filed an application to take up the suit on board for considering the defendant's counterclaim. As the defendant was not diligent in prosecuting his counterclaim, in view of the same, as the plaintiff defendant is not vigilant in pursuing the matter, and the application is filed after lapse of more than 1 year, 8 months, the same is not maintainable. Hence, the petition filed to restore the suit for adjudication of the counterclaim is dismissed. Agreed thereby the defendant number 2 to 7 are before this court. Land counsel for the petitioner submits that in view of the earlier dismissal, he submits that his counterclaim is filed immediately along with the written statement. When there is a mistake on the part of the court, when there is a counterclaim, because of the lapses on the part of the plaintiff, when the court is dismissing the same, court ought to have taken into consideration the counterclaim. He submits that though there are lapses on the part of the defendant also, considering the suit is filed for the relief of the suit is filed for the relief of partition, court ought to have considered the said application and ought to have allowed the application. Land counsel appearing for the respondent plaintiff submits that as the suit, as a restoration order was passed on the condition of an amount of rupees 5,000, and admittedly they have not paid the said amount. as such, the suit is not restored. She submits that as the application is filed almost after 1.5 years.
1 year,
and
8
without a
months.
condonation of delay petition, the court has passed this order. And he submits that court, considering the lapses on the part of the respondent, on the part of the defendant, had rightly dismissed the petition. Having heard the counsels on either side, peruse the material on the court. This is a suit for partition. Unfortunately, the suit which is filed in the year 2001, now by under writ petition that is filed in the year 2017 is still pending. The plaintiff, in spite of an order where the suit is restored, had failed to comply with the conditional order. And it appears that he is not interested to pursue the matter. When that is the case, any order that is passed by this court or the other lower court, the defendant, the plaintiff would not cause any prejudice to the plaintiff. Now coming to the observation of the court that when there is a counterclaim, it should have been brought to the notice of the court. When the court is passing an order and when all these things should also have been taken care of by the court, and it is all equally the responsibility of the party. But however, considering the fact that already a counterclaim is filed along with the written statement, this court is of the view that an opportunity should be given to the defendant. But when he files this application, when the suit is dismissed, he should have filed an application to restore the same. But such an application is not filed by the defendant. Considering all this, the order impugned is set aside, and the petitioner is permitted to file an appropriate application within a period of 15 days from the date of receipt of the copy of the order. Yes.
I may be given liberty to contest the counterclaim.
What liberty you will get now? You didn't pay that 5,000. No, that has to be questioned.
No, that is only in respect of restoration of my suit. So far as
that is, nobody can stop you from.
so far as the counterclaim is concerned, I should be given I may be given an opportunity.
No written statement.
That is it.
Writ petition is disposed of. Yes. If they're ready, we'll take 19.
19,
Lord, I
19.
appeal to the respondent.
Telecast Gowda. Vishwanath.
Now at 4:49, now your history can't again, the court can't pose this matter on 24th. Yes.
Till number 20, adjourned 21.
20? 26 not possible. Yeah. When is it posted now? 24? It can be 23rd. 24. Yes. I'll call the matters. Anything for extension you can tell. Now 21.
21, Aishwarya.
Let this matter come up on 25th. Yes, 23rd.
20, 22, adjourned 23, 23.
For the respondent, ma'am.
Yes, 20, the CPC of 2022. It can come on 31st. Yes.
Number 24, Omkar Basma Prabhu.
CPC of 2022. Yes, same 31st. Interim order granted. Earlier is extended.
Till number 25.
25, I appear for the respondent, my lords, any date which my lords please.
Yes, 22, it can go August 5th.
Lords, though it is 22, the suit is of the year 2001.
2001.
This is subsequent
Then
execution.
it should go Monday.
Any day, my lords, any day which, this is execution proceedings.
Of 20, of 12. Commercial bill 12.
He says 2001.
My lords, suit has been decreed, they have filed an execution, we have
That is
taken.
not, what is required, when is a decree, which year is a suit? So this is on Monday.
Till number 26.
Interim order earlier granted is extended till then. Yes.
Till number 26.
26.
Anant
Yes.
Narayan.
Respondent 1.
CPC.
Which year is the suit?
Anant Narayan,
Huh?
2011.
2011 suit. This is also on Tuesday. This is on Tuesday, 23rd.
Serial number 27, Suresh K.
Monday. Which year there is the suit? 2020, then it can wait. You're for the respondent or the petitioner? Notices are served. No, I'm saying to suit is of which year? 2020. So there are other matters which are more urgent. Suppose this matter on 6th of August. Interim order earlier granted is extended till then. Yes, 28.
28, Manjunath B. Petition.
23. Post this matter on 31st. 23rd. Yes.
Serial number 29, Adjournment, 30.
Thursday, the report of demands has come. Read the same. I've had no visitation for almost a year after August any day.
Why? No, court will see if the order is there of the imhans. No, post this matter on 25th. Yes. You cannot ask for it. You can't ask for the date whenever you want. Huh? She need not come. Why should she come? Why should a party is required? Did I ask the party to come? Then why is she coming? And let her not come to the court. Yes.
Serial number 31, Rangaramu B. CV Keshavamurthy,
Yes, 31.
31.
26th, not possible. 29th will have.
39.
Yes.
Serial number 30.
32, 33 and 34, let it come tomorrow.
18.
There's a passed over matter also,
Five hours.
item 16.
Yes.
Thursday, my lords.
16 is what, CPC matter or
The
FCC?
CPC and 2012 suit.
2012.
It
so
is,
we'll take it up. We'll take it up on
Monday.
23rd, not Monday, Tuesday.
23rd.
And don't ask for a Passover again. Morning Passover, afternoon Passover, again a Passover.
Then 16.
20,
Serial number 16.
interim order earlier granted is extended till then. Yes.
Serial number 36.
Can it be on 20? I'm sorry.
Oh,
Can it be on
35.
24th?
1 minute, huh?
Can it be on 24th if it is?
24th, yes. In which one? No, we have to, no, we'll see it. No, this. Non-receiving copy of hand summons from this of so-and-so, acceptance of memo dated so-and-so. Drawn in favor of the Registrar General, which is FC of 2024. For details from the caption for dismissal. For this matter on August 13th. Interim order earlier granted is extended till then. Yes, 36.
36.
It's there. Now it has to be ordered. Post this matter tomorrow. Let it come tomorrow. And if the tomorrow means
18.
Thursday. Yes, 37.
37.
My lord, for the petitioner, my lord. My lord,
This also will come on Thursday.
interim order is there, my lord.
Interim order earlier granted. No, this matters, all 16 matters on the top of the list on Thursday. Any matter in whatever caption it is, this old matters on the top. Yes. Yes, 38.
38.
Lakshmi, kindly have it on Thursday, because last time the matter was put for
Thursday.
dismissal.
17 matter will come on the
Right,
top of the
Top
list.
of the list.
Yes, top of the list. Next matter, 18 also will come on the top of the list.
My lords, it is fortuitous.
Which one?
Figure number 39.
39.
Matter arises out of an interlocutory order passed in a regular appeal. Now, the appeal itself was dismissed yesterday, my lords, 15th of July.
Tomorrow it will, Thursday it will come, we will see. Yes. 40.
40 Adjournment.
Yes.
41.
You have filed the IA. Tomorrow, Thursday, we will see, Thursday. Today, how many matters are posted? We'll see, let it, it's okay. No, interim order is extended till the next date of hearing. Yes, no, 42.
Till number 42. 42 for orders acceptance of postal track sheet. Item
This matter on Tuesday, 42 Tuesday.
57. Sale number 43, H.N. Basava.
Tuesday, all these CPC Tuesday, 43, 44 Tuesday, 45 also Tuesday, 46
46.
Tuesday. Interim order earlier granted is extended. Third, serial number 36 also, if interim order is there, extended. Next 47.
47, I'm for petitioner.
Yes.
Next week, any day.
Acknowledgement filed by advocate having served copy on CPC of 2021.
25.
No. Post this matter on 31st.
31st.
Yeah, 48. Delete, so if it is in dismissal, delete it. Yes, 48.
48. 30.
This also FC matter, post on 31st. Yes.
49.
Which one? 48.
Sale number
49. Memo filed with Sallas of this one.
51A.
Yes, this is also post on August 12th. Interim order earlier granted is extended till then.
Sale number 50. Keshadri GR.
Some FC 2023 post on August 12th.
Sale number 51.
Appearing for the petition,
And
my
from
lord.
K.
We have served the respondent of the trial court, my lord. Notice.
Yes, sir. File a memo.
Yes, ma'am.
Any urgency in this?
Yes, my lord.
Post this matter on Tuesday, 23rd. Yes,
52.
2024 GMFC matter, 12th of August.
50. Reserved. 54.
My lord,
53, may I make one submission, Lord?
50.
In that matter, my lord, I had served the copy on the other side. I have made my return points, only one page. My return submissions, my lord.
You can
I'll
give to
file
the
it
court.
with the court.
In that reserved matter, afternoon matter.
I'm
2
sorry,
o'clock,
I
take
could
it.
not mention it.
No problem. Yes. Yes.
Submission, my lord. Serial number 34. Serial number 34, date has been given on 18/7. Kindly have it on 19th. 18th, I'm not in station. I'm going to Anantapur for a case.
Which case?
Serial number 34.
Serial number 34 instead of 18th, it should be 19th, not possible.
Any other date other than 18th?
22nd.
Much okay.
My lord, CL number 42, my lord.
The leave of the court. Seal number 30. Nimhan's report is before the court. If I may kindly be permitted to peruse the report, your lordship, and for the petitioner.
No, it is a little difficult with all this. Let's see, like when the matter reaches.
My lord, CL number 42. Interim order may be extended, my lord. CL number 42.
You were not there when the matter
My
got
lord. I was just entered into the
42 interim order extended. Even if they're not mentioned, if it is there, extend. Directed to bring the name. Not bring, this is printer.
Court officer? Court officer?
42 date our photo.
Court officer?
Sir, ಹೇಳಿ.
Madam, serial number 6 ಏನಾಯ್ತು madam? Serial number 6.
Number
6.
ಹೌದು. ಆಫ್ಟರ್ನೂನ್ ಏನೋ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಇಟ್ಕೊಂಡಿದ್ದೆ.
ಅದು parted and 23/7 ಗೆ ಪೋಸ್ಟ್ ಆಗಿದೆ as parted.
ಓಕೆ ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಮೇಡಮ್ 42 ಡೇಟ್ ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ?
MFA ದೆಲ್ಲ ಇವಾಗ
ಅದು ಡೇಟ್ ಆಲ್ಟರ್ ಮಾಡಿದ್ದೇವೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 34. 34 ಒಂದು ಯಾವತ್ತೋ ಹೇಳಿದ್ರಲ್ಲ.
serial number 34
18 ಬೇಡ ಅಂತಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡಿ ನೋಡ್ಕೊಂಡು ಫೈಲ್ ಕಳಿಸ್ಬೇಕು ಅವ್ರಿಗೆ.
22/7 ಅಂತ.
22/7.
ಬಾಕಿದೆರಡೂನು ಮಾಮೂಲಿ 18.
Hello, court officer.
ನೀವು ರಿಪೀಟ್ ಕೊಟ್ಬಿಡಿ, ನಾನು ಬಾಕಿ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು.
ಹೇಳಿ.
Court officer?
ಯಾವ್ದು ರಿಪೀಟ್ ಕೊಡೋದಿಲ್ಲ ಎಲ್ಲ ಫೈಲ್ ಹೋಗ್ಬೇಕು ಅಲ್ಲೆಲ್ಲ ಏನೇನು ಆರ್ಡರ್ ಆಗಿದೆ.
ಎಲ್ಲ
Hello?
ಬರ್ಬೇಕು ಮತ್ತೆ
ಹಾ.
ಮಾಡ್ಬೇಕು ಎಲ್ಲದಕ್ಕೂ.
ಹೌದು ಹೇಳಿದ್ಯಲ್ಲ ಹೇಳಿದ್ದೀರಾ?
Hello, court officer?
ಮೇಡಮ್ ಹೇಳಿ.
Madam, ಅದು 10 court serial number 10 ಅಲ್ಲಿ last ನಾನು I was not able to hear what
42.
order has been passed. Could you please let me know what is the final word actually? Serial number 10.
Memo for posting, memo for posting ಅಲ್ಲಿ ನೋಡಿ.
Number 10, that petition is disposed of.
ಏನಾಗಿದ್ದು ಮೇಡಮ್ ಅದು
I can't, that dictation is taken by the stenographers. That entire order we will not listen because I am busy with the proceedings, other matters.
No, madam, the last one, whether
It is
that is
disposed of, disposed of with some directions.
with directions. Okay. Madam, ಅದು set aside ಆಗಿಲ್ಲ, just I wanted to know the last one.
Madam, that matter is disposed of, not that you take the order after that scanned. After
Okay.
scanning, that order is uploaded, you take the copy from the list, ma'am.
Okay, when can I get that one, madam?
You will get.
It
As
will
soon
take
as-
some days. No, madam, what I'm asking is whether last.
Madam, what you are asking, all your questions, I am the court officer, I can't answer to your questions. Your matter is disposed of, that much I can tell.
That means their petition is not dismissed.
You take that order from the web host when it is uploaded.
Okay, so it is disposed of, not dismissed. Okay.